Session. The Honorable Donald Capper presiding. All those having business before the court, draw near and you shall be heard. God bless the great state of Ohio and this honorable court. You may be seated.
Good morning. Welcome to Lawrence County Municipal Court. I'm Judge Capper. A busy docket today, so be patient. We'll get to you. We have several reviews to do. When your name's called for review, come up to the table to your right. If you didn't get called or don't get called, think you should have, go check in with the clerk's office. If you missed a hearing before, you're not going to be on the docket today unless you let them know you're here. So call the reviews.
Christopher Blake, Nathan Boyd, Taylor Bryan, Alexis Kane, Douglas Jeffries, Robert Gearhart, Joseph Graham, Jessica Leggett.
Christopher Blake. Christopher Blake, 23,440 and 18,357. Have reviews, need to be in the courtroom. Christopher Blake's been called, has not appeared, is not finished, so it'll be a warrant. Nathan Boyd.
Yes, sir.
This year, 21331. Is it Southern Hope? 2434. Okay, it looks like you missed a urinalysis, so I'm going to redo one here today. So go do a urine screen.
Okay.
Come back after we get that done. Taylor Bryan. Taylor Bryan is 23,112. She has lots left to do. It hasn't appeared to be a warrant for failure to appear. Alex Kane.
May I approach, Your Honor?
Yes. Is it Alexis? Okay, sorry. Is that Bethesda? Okay. We're using a lot of urine screens today, so you need to go do a urine screen too. Come back after you get the screen done. Douglas Jeffries, 23,438.
May I approach, Your Honor?
Yes. It's supposed to be outpatient with you.
He was inpatient with us because he graduated from OMP to residential and then went on pass and never returned.
All right. The bench warrant issues, left treatment, and didn't appear for his review also.
Thank you, Your Honor.
Robert Gearhart is not here.
Your Honor, Mr. Gerhart is currently in the Gallia County Jail. I discharged him for leaving Common Pleas Court and going home to do what he felt like.
Okay. And how did he get to Gallia? What happened in Gallia County?
Common Pleas revoked his bond, so he's incarcerated in the Gallia County
So it
Jail.
was Gallia County Common Pleas.
Well, no, it's Lawrence County Common Pleas, but they're housing him in Gallia.
Oh, okay. Now I got you. Overcrowded. All right. He'll get warrants from this court then for failure to appear today.
Thank you, Your Honor.
And I guess we'll need to let them know, and then when he comes back for comment, we can get him here too. They don't need to make a special trip to get him just for us. We'll do it at the same time Common Police has him. Okay. I would say they'll probably bring him back Wednesday for Common Police, so we can do it next Friday. Joseph Graham, 2375, 2375.
Your Honor, he is compliant with all of his outpatient requirements currently.
What about screening? Do you know what?
Yes, they said they were all good. He didn't bring his physical report, but I can send it to you later once they email it to me. I spoke with them this morning, though.
All right. Can you pay anything on your fines?
I was gonna pay Monday.
Okay. December 4th will be your next hearing. 9 o'clock. Jessica Leggett.
Thank you, Your Honor.
You're welcome. 21-11-51. Is that Linda Reeves?
Yes, Your Honor, she's been doing really good. She's been compliant.
Very good. Now, is she inpatient or outpatient now?
She's in community. She's living in her own home,
Okay.
but doing services.
All right, well, we've got some community service and fines to pay too, so when can you get out to do some community service?
As soon as I can.
Are you living in Ironton, or where do you live in
Ironton.
Ironton? You can do it at the dog pound.
Okay.
That's, or Ironton Municipal Court. Either place is right there in Ironton, so
Okay.
you got 5 days of community service to do. Can you pay anything on your fines today?
Yes,
How much?
I can pay 40.
Okay, see the clerk to the right as you leave, make a payment, get some of your community service done, keep up with, you're doing good on your treatment. I'll set you for December the 11th as your next hearing, 9 o'clock.
Thank you.
You're welcome.
William Joel Myers, Jared D. Nance, Kaylin Rhodes, Mitch Rife, Stephanie Romans, Edward K. Russell, Levi Schaefer, and Melissa Weaver.
William Joel Myers, 22-27-12. William Myers. On call, has not appeared, hasn't done anything on this case. So you don't get a warrant for that. Jared Nance, 22-08-12. Set RRS. Human service is done. Got a job now? Congratulations. Negative drug screens. Excellent report. Good job, sir.
Thank you.
Okay, so you did quite a bit of community service since your last time you were here. I'll let you work or pay, or a combination of both on your fines. You get $50 a day credit for extra community service you do, or you can pay it. Can you make any payment today?
Yes, I was gonna pay $20 today, where I just got a half check on this first check.
That's fine. As long as you're making progress, we'll work with you. Good job.
Thank you.
I'll set you for December the 11th also for your next hearing, 9 o'clock. Keep up the good work.
Thank you, Your Honor.
Thank you, Your Honor.
Caitlin Rhodes, 21-834. And you've done a couple days community service. You got 1 day left, I'm showing. And fines today. Do you have a payment on your fines today?
No, I do not today.
And you still have to do the driver intervention program, are you aware of that?
The next one they offer, I think, is like the 16th of this month,
Okay.
but I can't afford it this month.
All right, well, you just have to do that, or have to, according to the statute, I either have to give you jail or you have to go to that program, so you'd rather go to the program than do jail, right?
Yeah.
So get it done. Get your community service finished, you've got it almost done. December the 8th will be the next hearing. That's a Friday. December the 8th, 9 o'clock. Mitch Rife, 08-29-19. Okay. You just have $138 left.
Yeah, I'm gonna pay it as soon as I get out of here.
You're gonna make a payment today? How
I'll
much?
pay it, all of it.
All of it?
Yep.
Okay. Here's what I'm doing, because sometimes people lie to me, believe it or not, even in the courtroom, they'll lie to me and say they're gonna do something, they don't do it. So I'm gonna give you a date, and then if you've paid it off, you don't have to come back. So your next hearing date will be December 1st. If you pay it off, you don't have to be here.
Is there any way I get a piece of paper saying it's all done? Or-
Get it from the clerk.
All right, thank you.
Stephanie Romans is here. 17-30-10 and 17-10-8. Okay, looks like you're making progress, still stuff you're working on.
Yes, sir.
Okay, that's progress. You've got some community service and some fines to pay too. Can you do anything on those?
I did community service.
Okay,
I didn't,
all right, well, it's too soon to get in the file yet, but.
and I
keep
did
working on it.
$150 in October too.
Okay. I'll set your next hearing for December 4th.
All right.
Keep working, you're doing good.
Thank you. Thank you, Judge.
Edward Russell, 2385, 2889, 222675, has not appeared and has things left to do. So it'll be a warrant issue for you. And your name?
Levi Schaefer.
What is it?
Levi Schaefer.
Levi Schaefer. I don't have this file. I might have handed it over. We'll find the father. Melissa Weaver, 16490 and 10251 has not appeared. Has things left to do. So be a dead.
License, they're gonna call you back.
Levi Schaefer. Mr. Schaefer, just have a seat. We'll misplaced your file. We'll find it.
Recall Nathan Boyd. Case numbers PRC 21335, CCD, and others.
Okay. Tested positive for alcohol, that was the only thing. So, make note.
Okay.
Next hearing, December 4th.
None, sir.
Yes, sir.
Thank you, sir.
State of Ohio recalls Alexis Kane. Case number PRB 23502.
Your Honor, we did perform a screen. It had no temperature and no color.
Okay? Back to the holding cell. We'll wait till we get one with temperature and color.
Thank you, Your Honor.
Probably be toward the end of the docket. You should be able to pee by then, because we're going to be here several hours. Okay, that finishes the reviews. We're going to start with the new cases called arraignments. It's a fancy legal term for it. If you're here for a new case, or if you missed a hearing on an old case, you're going to get called as long as the clerk knows you're here. Come in and have a seat, please. There's some seats up front, and then the second row over here. Sir, have a seat. Or leave. Leave or have a seat. You're holding me up. So get out. Take him out. Get this guy out of here. Out. I ordered you out. Yes, sir. Come in and have a seat so we can get started.
State of Ohio versus Tracy.
Hold it. I'm not ready. I was going to give them their rights. I haven't had a chance to do it because people parading in and out of the courtroom. Okay, you have a right to have an attorney. You have a right to remain silent. You don't have to make statements. If you do make statements, it's all on the record. What you say can be used against you. You have a right to have an attorney appointed if you can't afford one and you're facing a jailable offense. You have a right to bail. You have a right to make the state prove any charge filed against you beyond a reasonable doubt. Those are your rights. If you enter a guilty or no contest plea, you're waiving those rights, and you should not do that if you don't understand the proceedings, or if you want to talk to a lawyer, or if you want to have a trial on your case. For any of those reasons, you should enter a not guilty plea. That's the safest plea you can enter. Call the first case.
State of Ohio versus Tracy M. Pauly, case number TRC 23-1600 A and B.
Good morning, Your Honor.
Good morning. It's Mr. McCown's case. Do you wish me to read the complaint?
Your Honor, we'd waive reading of it, enter a not guilty plea. We would ask for a pretrial on November 17th. We've already...
We can't do that date. We have a jury trial that day. I think that's with you.
It is with me. That's why I was hoping to get it down here as well.
I'm keeping it. We've already got cases. I want to rather not send any more that day.
Certainly, Your Honor. I could do it if the 20th would be okay.
Okay, that's acceptable. November 20th will be the next hearing.
Thank you, Your Honor. I do have, we filed the notice of ALS appeal for the record. I do have an agreed upon entry to be effective after the hard suspension, if that's okay for driving.
Yes, Mr. Heal's already approved it?
Yes, Your Honor.
Okay.
May I approach?
With that, yes. All right, Ms. Pauley, has she posted a bond? Any kind of type of bonds you just decided to appear? She can sign an OR bond of $1,000. Next hearing date's November 20th. I've executed your entry if you want to get a copy from the clerk.
Thank you, Your Honor.
Clerk's office.
State of Ohio recalls Levi Schaefer, case number TRT 22-2675.
Okay. We got your file now, Mr. Schaefer. 22-2675. You haven't done anything on this.
I paid some fines this morning.
This morning you did? How much
Yeah.
did you pay?
$250.
All right, that'll be acceptable then. You got community service to do.
Yeah, I'm just been working out of town, so it's kind of hard for me to get in.
Well, it's supposed to, that's kind of the idea. It's supposed to be hard. But you got to do it.
Yeah.
Give me a commitment. I need a commitment because this is an older case. We need to get some of that done. We have community service 7 days a week.
Where can I go to do
You can
it?
come here tomorrow. Are you in town tomorrow?
Yeah.
Be here tomorrow morning at 7:30. Come to the west side of the building.
Okay.
Mr. Cooper's he'll be here with you.
Okay.
Now, do you know your schedule? Who do you work for that has you out of town?
Summit, environmental,
Do you know what your schedule will be about a month out?
no,
Is it better Mondays or Fridays?
yeah, probably Fridays.
Fridays. December the 8th will be your next hearing. That's a Friday. At 9 o'clock. Once you get this completed, get your community service and your fines paid, then you want to come back, obviously, to these hearings.
You said 9 o'clock?
9 o'clock, December 8th is your next hearing.
Okay, thank you.
See you in the morning, or Mr. Cooper will see you.
Okay,
7:30.
State of Ohio versus Samuel W. Julian, case number TRC 23-1598, A and B.
And sir, you're Samuel Julian?
Yes.
Mr. Julian, the state's alleging that on October the 29th at 1:02 a.m. in Fayette Township, you were driving a vehicle while you were under the influence of either alcohol, drugs, or a combination of those things. And so as this would be your first offense, so there's progressive punishment on these. So on a first offense, the maximum is 6 months in jail, a $1,075 fine, and a 3-year license suspension. That's the most you can get if you're found guilty. There is a minimum, so the least you can get on this offense, if you're found guilty, is 3 days in a treatment program, $375 fine, and a 6-month license suspension. You're also charged with driving outside your lane violation. That's a minor misdemeanor. The maximum penalty for that's a $150 fine. So those are the 2 charges you face. Do you understand that?
Yes, I do.
And were you here when I explained the rights of the defendant?
Yes, I did. Yes, I was.
You have any questions about that?
Nope.
What plea do you wish to have?
Not guilty.
You want a lawyer appointed to represent you?
Yes, please.
Are you working?
I am.
What do you do?
I work at Sam's Club. I'm a sales manager.
I have to determine your gross annual income to decide if you're qualified for, not everybody's qualified, depends on what your level of income.
Well, if I have to, my sister's a lawyer in New York, but I prefer to make her come out here, but I can, if she had to, I'm sure she would.
Well, she's got to be licensed to
Oh, okay,
practice in
okay.
Ohio.
I got you, I understand.
I mean, she can maybe give you some side advice, but you have to be admitted to practice in the state
Okay.
where the court's located. Or there's a special way to get admitted, pro hoc visa, but that's some work to do that. So I would suggest getting someone that practices in this court on a regular basis if that's what you want to do. So do you still want me to consider you for court-appointed counsel? I'll have to ask you about your income then.
I mean, I can look for a lawyer. I'm moving back to Illinois. I'm really moving back as soon as this is done, so whenever, I guess, I'll look for one, I guess, but I prefer to have it appointed because I really don't know anybody out here.
I have to determine your gross annual income. Do you have a salary? You pay by the hour?
No, it's hour, per hour.
How much per hour?
It says 16 right now.
And are you working 40 hours a week?
Well, 30 to 40.
Oh, you're not full-time?
Well, it's full-time, but I'm 38. Sometimes the full-timers are 38 to 40 hours a week.
Oh, 38.
Sorry, yeah.
Okay, well, I'll split the difference and say 39 hours times 16. So I get you're making about 32.5 gross a year, is that right?
Give or take without tag, yeah. Yeah.
So do you have any dependents? Do you have anyone you're supporting on your salary?
No.
Okay. Well, you make too much money for me to court, for a single person, you're over the limit for court-appointed counsel, so you'll have to hire one on your own.
Okay.
How much time do you need to do that?
I'm going to make calls because I don't know nobody out here, so.
Let me look and see. I'll give you plenty of time then to get a lawyer. Could do the 27th of November, so that's almost a month, or we could go into December. What do you prefer?
I can do November. I'll make some calls. I'll start working on it today.
November 27th is going to be your next hearing.
Okay.
It's called pre-trial.
Okay. At 9 a.m. again?
No, that'll be at 10 a.m.
10 a.m.? Okay.
On November 27th, I've entered a not guilty plea for you. And I'm going to let you sign a signature bond. What that means is a bond is a guarantee of appearance, so you're signing something that says, I promise to pay $1,000 if I don't show up, plus you get a warrant. So as long as you come to court, you don't have to post any money. If you don't come, you're gonna get a warrant, and then you gotta pay $1,000 for not showing up. So come back November 27th, unless you hire a lawyer that tells you they've made arrangements for a different date.
Okay.
Any questions, sir?
No, thank you.
That's all.
Thank you.
You're welcome.
State of Ohio versus Brian K. Stapleton. Case number CRB 23593, CRB 22573, CRD 23983A and B.
Sir, you're Brian Stapleton?
Yeah.
You received a copy of the charges?
Yeah.
23593 is an assault charge. It alleges that at Sims Township, on September the 13th of this year, you knowingly caused or tried to cause physical harm to Alexis Rice. That's a first-degree misdemeanor, maximum penalty 6 months in jail, $1,000 fine.
Your Honor, that was me that done
Ma'am, you're out of order. 22573. It's alleged that you had a review hearing on October 27th at 9 o'clock and failed to appear at that hearing. That was on a theft offense. 23983 also was set for a review hearing on October 27th on a no operator's license. It's alleged you failed to appear for those hearings. Do you understand the charges, sir?
Yeah.
Do you understand your rights?
Yeah.
How do you plead to these charges? And you can plead differently to the different charges.
With the Alexis Rice, not guilty. The other two that I'm here on, I already paid money on it, and I was out of town working. I couldn't get back into town because I work for a company and I don't have a driver license, so they have to arrange for me to get here.
Okay. Well, let's deal with the most recent case first. Let's have the prosecutor come in and talk to the complaining party, who's Alexis Rice. You're Alexis Rice, ma'am?
Yeah.
Yeah, that's my daughter.
Come up and talk to the prosecutor. He's going to come in the courtroom. This is Brian Stapleton. It's on an assault charge. We've got the victim here, who I think is going to tell you they don't want to go forward with the case, but you can talk to her.
Your Honor, what's the date of the offense?
September. It was in September. September the 13th. And you did make a payment on your old cases today,
Yeah.
it looks like.
Yeah. Made 2 payments already.
Now, this young lady, Your Honor, is the alleged victim in this matter, and she says she's continued to be in the same household since this happened, and she doesn't want a protection order. She was urging me to drop the charges today, but that would not be something we'd be willing to do today. However, we would be willing to continue the case and make sure that there are no further problems.
Okay. I'll enter a not guilty plea for you, Mr. Stapleton. Do you wish to be considered for a court-appointed lawyer, or do you want to hire your own lawyer, or how do you want to proceed? Do you want to be represented in this case with your daughter?
Yeah. I don't know what the hell's going on here. I mean,
Okay.
my daughter's dropping
Back in the holding
charges.
cell. You don't need to talk like that. Unacceptable. You were late to court. You didn't show up before, then you come in and want to talk like that. Not acceptable. So you can go back in the holding cell. I'll bring you out later. You can sit for a while and think about it.
State of Ohio versus Freddie L. Atkins. Case number CRV 23437.
You're Freddie L. Atkins?
Yes, sir.
Okay, you had a pretrial on October 30th, and Mr. Stratton's your attorney, correct?
Yes.
He's here today.
Yes, Your Honor.
This is your client, and this hearing on October 30th is alleged. I'll let you talk to him, and then we'll call it back up after you've done so.
Yes, Your Honor. There's no problem.
State of Ohio versus Elijah Mills. Case number TRD 222577. Elijah Mills.
Here, Your Honor. All right, Mr. Mills is here, and you're at Southern Hope now?
Yes, sir.
Yes. His case number is 222577. So I assume, are you self-admitted to Southern Hope, or do you get?
Correct, Your Honor. Yes, sir.
Okay. Well, I applaud that, taking care of that issue. This was a traffic case that looks like you missed, didn't come to court on, it's alleged. The allegation is that on October 27th of 2022 at 7:50 a.m. in Perry Township, you were driving a vehicle without a driver's license. That's a unclassified misdemeanor. Maximum penalty is 500 hours of community service on $1,000 fine, and it's alleged you missed your arraignment, which was November the 8th of 2022 at 4 p.m. So you're coming in today to clean that up, I assume?
Yes, Your Honor.
Do you understand the charge against you?
I do, sir.
How do you wish to plead to it?
No contest, Your Honor.
No contest means you're not fighting me.
Correct.
Okay, the officer says defendant was traveling east on US 52, approaching a lane closure in a construction zone. He passed a car on the right berm and stopped his vehicle for the passing violation. He produced an ID card, did not have a valid license. He said he was in the process of getting his license. Have you ever had a license, or?
I have previously, sir. With honest, full disclosure, I've been a homeless drug addict for several years, and I've making an attempt to clean my life up, sir.
Okay, well, that's good. That's what, and going back and cleaning up your past mistakes is part of that process. So what I'm going to do then, I'll accept your no contest plea and make a finding of guilty based on his plea and the officer's statement. Did you want to say anything contrary to what the officer said?
No, Your Honor.
Okay, I'm going to impose a $100 fine on the no operator's license. And I'll suspend it on the conditions you finish your treatment.
Thank you, Your Honor.
And I'll just have you pay the court costs.
Yes, sir.
So, fine suspended on condition you complete treatment at Southern Hope. And I'll set a review hearing for you in about 6 weeks, so we'll see where you are. You just got started in October, right? With your treatment, so you're going to be doing this a little while.
At least 6 months.
Okay.
Your Honor, showing that he does not have, he didn't show proof of insurance at the time of that.
I'm going to guess that you probably didn't have insurance, did you?
I did not.
Okay. Well,
The vehicle, if it's of any consequence, was not my vehicle.
well, did they have insurance?
I don't know, Your
Who
Honor.
was it that owned the vehicle?
My ex, Your Honor.
Well, here's the way this works. It's kind of a screwy system. It's not what I would set up, but they didn't ask me. In Ohio, you just have to sign, when you get your license renewed, you sign this thing, and they don't even tell you what you're signing. They say, here, sign here. It says, yes, I have proof of financial responsibility. You're not allowed to say the word insurance in a courtroom here. So it's what you're saying is I have insurance. You don't have to show proof of it. You just sign this document saying you got it. But then when you get pulled over or have a citation, you're supposed to have that little card.
Correct.
That says you've got insurance. Or it goes to the BMV and they're going to suspend you. So you can have it either on yourself or the vehicle. So if the vehicle has insurance, it covers you as long as you're driving with consent. So if you can get her,
I could
I
not.
assume that you're not on the best of terms with her.
No, sir, that's why we're exiting.
Well, here's going to be the consequences. You're probably not going to make a big difference now because you're in inpatient treatment, but eventually I assume you're going to want to get your license back.
Correct, Your Honor.
Well, this is going to be a problem then because the BMV is going to suspend you for driving without insurance. So you'll have to go back and clean that up. And you could either do it by getting the proof that you did have insurance. If she had insurance on the vehicle, she'll have to give you the proof and you can submit it to the BMV, or you'll have to serve a time of suspension for driving without proof of insurance.
Okay.
You won't be able to get your license for a while because of driving without insurance.
What would be the quickest way to expedite that suspension through the BMV? Would it be?
Well, it's going to happen. I'm not the one suspending you.
Sure.
When we send this in to them, they're going to look at it and say he's driving without insurance. They're going to issue the suspension.
Okay.
When you're ready to start getting your license back, call them and see what can I do to get my license back.
Yes, sir.
All right, so anything else, sir?
No, Your Honor.
Okay, I'm going to make this probation 2 years of level 5 probation, and I'm just going to monitor you while you're in treatment. So I want to encourage you and also to think, well, at least the judge is paying attention to what I'm doing, and he's going to make me pay $100 more if I don't finish. So I believe in negative reinforcement too. My mom was really good. You know, you got carrots and sticks. She was more of a sticks kind of person than a carrots kind of person. I believe both can work. So a little bit of a stick. You didn't come here for substance use problems, but I'm giving you a break. Look at it this way. I'm giving you a break if you finish.
Yes, Your Honor. I appreciate your leniency.
If you don't finish, then you're going to have to pay $100 more, and I want to monitor what you're doing. So I'll set your next hearing for December 18th for a review hearing at 9 o'clock.
Yes, sir.
Okay, good luck, sir. I think you're on the right track. You're doing
Thank
what
you,
you
Your
need to
Honor.
do. Good luck with it. If you want a copy of the judgment entry, well, you need to go to the probation office anyway, because I did give you probation. So go there and I'll give you a copy of the judgment entry. To the left as you leave the court. You're welcome.
State of Ohio versus Kevin T. Donnelly, case number CRB 23364. Mr. Holt's case.
Is he here? Okay. We need Mr. Holt in the courtroom. There he is. Well, actually, this was your case. I think it was on a failure to appear for a review hearing, so you're off the case now. So, Mr. Donnelly, it's alleged that you had a review hearing on October the 20th and didn't appear for it.
Yes, sir.
Do you understand that allegation?
Yes, sir.
You admit or deny it?
I admit it.
Do you have an explanation?
Yeah, I was out of town working.
Okay, well, technically this trumps being out of town, but as long as you come in as soon as you can, where are you working?
I worked through Thoroughbred, and we've been out of town, Bark Camp. We just got back in last night.
Okay, you've got 1 day community service lesson and some fines.
Yeah, I paid $50 for my fines today.
I see that. When are you going to finish up your community service?
Probably this week.
Tomorrow?
Saturday. I only work Saturdays.
What?
I can only work on Saturdays. I
Well,
work 5 days a week.
That's tomorrow.
Okay.
Tomorrow at 7:30?
Yep. Yeah, I can do that.
Mr. Cooper's got you down. That'll finish up your community service. I'll set your next hearing December the 15th. Get it finished by then, you don't have to come back. 9 o'clock, December 15th.
Thank you, sir.
You're welcome.
State of Ohio versus Danella G. Smith, case number TRD 163387.
Okay, this this was a review hearing on October the 16th. It's alleged you didn't appear then.
I was out of state taking care of my granddaughter, and I did not realize that I had missed my court date until it was too late. I called the courthouse to find out what to do, and they sent me here.
Okay.
And I apologize.
You only have $110 left. When can you pay that, or how you want to do that?
I'm going to pay half, probably 50 today, and then next month I'll finish it up.
Okay, see the clerk to pay your 50, and I'll set your, this is an old case. So December 4th will be your next hearing. Get it paid by then, you don't have to come back.
Okay, thank you.
You're welcome.
State of Ohio versus Savon Stallworth, case number TRD 23859, A and B.
And you're Savon Stallworth?
Yes.
Stallworth, it's alleged on, this is an old case, July 3rd of this year at 4:24 p.m. in Perry Township. You were driving a vehicle while you did not have a license. That is a unclassified misdemeanor, maximum penalty 500 hours community service, $1,000 fine, and that you were not wearing a safety belt. That's a mandatory $30 fine if you're found guilty. And it's alleged you were cited into court at 4 p.m. on July the 11th, that you failed to appear at that time. Do you understand the charges?
Yes.
You understand your rights?
Yes, sir.
How do you plead to these charges?
No contest.
No contest means you're not fighting it, and you agree that you can be found guilty without having a trial with a lawyer. Do you understand that? Okay, the officer who is a trooper says US 52 near milepost 16, defendant was checked at 67 miles an hour in a 55 zone. Tags were expired as of March of 23. Defendant was not wearing a safety belt, and computer check showed his license was not valid. Are you valid now?
I'm not. I'm working on it.
Okay, also, officer checked the box saying no proof of insurance. Did you have insurance?
I don't believe so.
This was your vehicle or somebody else's?
Mine.
Okay, well, what I told the, I don't know if you were in here when I talked to the previous gentleman about long explanation about what happens when you drive without insurance in Ohio. B&B is going to suspend you for not having proof of insurance. So that's another consequence of this will be your, I mean, apparently you don't have a license now, but you're going to be prohibited from getting a license for a while due to this driving without insurance. Anything else you want to tell me?
I mean, so that day I actually remember I was leaving from finishing work. I only drove out this way to come to work. I was filling in for someone, trying to get some extra money.
Where you work?
It was for Lowe's that day. Lowe's delivery, yeah, delivering like appliances.
Well, little, you know, from an old guy to a younger guy, you got to use your brain. I mean, you shouldn't be driving without a license.
Yeah.
If you're going to drive without a license, on US 52, which is known for what? Being crawling with state troopers, it might not be a good idea to go 67 in a 55 zone when you don't have a driver's license.
That was another thing. I wasn't used to the 55 mile per hour. I actually assumed it was 65. I was pretty tired after work. I just was ready to get home. So honestly, I was thinking it was 70, 60.
You know the rest of that.
Yeah.
So you shouldn't drive if you're going. It's like the difference between being extra careful when you know you're vulnerable. Heck, what could go wrong here? You got to think about what could go wrong here.
Yeah.
And that can keep you out of a lot of situations in life. You know, a little foresight. Well, if I drive 67 And it's not a 60 mile an hour. None of this around here is 65.
Yeah, I'm from, so I actually live like 3 hours away in Columbus, Ohio. I just randomly came.
Well, you're in a different state now. That's Ohio. This is Ohio. It's totally different place. Totally different. Okay. What about not coming to court? Why'd you come in today and you didn't come in July?
Honestly, so I got into another situation out by where I stay, and the officer reminded me of that court date. I slipped my mind. I forgot I got a bunch of things going on. I'm trying to get everything together, pretty much. And
well, back to what I said before, you'll have less things going on if you kind of think about what you're doing as you're doing them. You get less of these kind of situations that you have to deal with. Okay, on the no operator's license, since you were late coming in, you did come in, so I'll give you credit for that, but I'm going to make your fine a little higher than I would have otherwise. So I'm going to make it a $200 fine. Because somebody that comes when they're supposed to shouldn't get the same punishment as you when it comes later. But at least you didn't go to jail. You took care of it yourself. You could have got picked up on that warrant. You had.
No, I did.
Oh, you got picked up.
Yeah, I bonded out. I paid like $1,000.
There was a warrant out for you for a while.
Yeah, I paid $1,000 to bond out.
Okay. And out in Columbus or where was it?
Jackson Pike.
Okay. Okay, $200 fine. It's actually a non-jailable. You made it into a jailable offense by not coming to court. It's a non-jailable offense. I'll order that you do 18 hours of community service. You can do that in your home area at a legitimate charitable organization, or you can come back here. We have community service here in court 6 days a week.
I'd rather do it out that way. It's a pretty far drive, and I don't have a license already, so that'd be...
All right. Hours community service. I'll make it level 5 probation for 2 years, just till you pay it off. Once you've paid it off, your probation ends.
200.
You got $200 fine and 18 hours community service. So
okay.
You got probation. You're going to speak with the probation officer before you leave. I'll set his review hearing for May the 3rd. So it gives you a long time to get this done. If you don't do it by May 3rd, you got to show up. That's the only other way you can wind up making it jail. Blow it totally off. Don't do anything.
Yeah, my daughter's birthday is May 8th too.
May 3rd if you don't show up and you haven't taken care of it.
My daughter's birthday is May 8th, so yeah, I definitely need to make sure.
On the seat belt, that's a mandatory $30 fine. Okay, so now you're going to go to the probation office. When you go out those doors into the lobby, 90-degree turn left to the west side of the building. That counter over there is probation. So go talk to Mr. Major. He'll give you everything I just told you on a piece of paper. That's your judgment entry. And then he's your contact person with the court if you've got issues you need to talk about. Any questions of me?
No questions.
Okay, go see Mr. Major. After that, you're free to go.
All right, thank you.
You're welcome.
State of Ohio versus Reba L. Ailiff, case number CRB 04435.
04435, Reba Ailiff.
Yes.
This is from an old case and review hearing October 1st, 2018.
Yes.
It's alleged you didn't appear for your review hearing, had a warrant issued.
Yes, correct.
Do you admit that then?
Yeah.
Do you have an explanation?
Yeah, I was actually I was just really bad out there on active addiction. Since then, I've been clean since 6/22/22. I have supporting documents of all of my drug screens from PROACT, from the SRO apartments I live in. I've since been released from probation. And
Where are you on probation?
Wayne County, West Virginia. Yeah, I had 5 years probation. I also have full-time employment.
Magistrate's court or circuit court?
It was a felony. Yeah. So it was a
Judge
felony
Young, or
charge.
who was your judge?
My judge was young. Yeah. So. But I'm also a full-time employee with Goodwill. I'm an assistant manager at the store. So
And you
I'm
got
just
some
trying to.
documentation?
Yeah.
Okay, let me take a look at it.
There you go.
Okay, this was a theft offense?
Yes.
Here with, looks like Walmart theft?
Correct.
Which I get a lot of the people that shoplift at Walmart are in active addiction.
Yes.
Okay, you got a good report here from Prestera. And you got a judgment entry from Circuit Court. James H. Young Jr., Circuit Court Judge. I saw him this morning at the Huntington Walk. Okay, I'll accept that as proof that you are in recovery.
Yes.
You still have to take care of what you're going to do here. You did make a payment on your fine, so you only have $122 left.
Okay.
You got 5 days of community service.
Okay.
So I won't give you any additional punishment as long as you take care of this stuff and get it done.
Okay. Yeah.
I'll withdraw the warrant that had been issued for you.
Thank you.
And the way we work this is I'll give you review hearings. You'll keep coming back until you get it finished.
Okay.
So, I'm going to set you up in January. And hopefully you can get it done in that time frame.
Yeah, and you said that they can do community service at the dog pounding over in Huntington, right?
Ironton.
Oh, okay, okay.
You can come here.
Right.
You can come here 6 days a week.
I can only do it like 2 days a week because I work full-time at.
I understand.
Okay.
We'll work with you on that.
Okay.
I don't want you to lose your job. I want you to keep your job. What's your work schedule?
It kind of fluctuates. We're on management. It just kind of moves around sometimes.
You can work here any day but Sunday.
Okay.
Here at the court.
Okay.
7:30 a.m. Or holiday. I'm going to set you for January 12th, so that gives you over 2 months to get it done. If you get it done, you don't have to come back.
Okay.
If you haven't got it done, you got to come back and appear, or I'll issue another warrant.
Right, I'll take care of it.
January 12th, 9 o'clock is your next hearing.
Okay, thank you.
You're welcome.
State of Ohio versus James McClellan, case number TRD 21682, TRD 181168, TRD 163521, A and B. James McClellan. James McClellan.
Okay, James McCollum has not appeared, so there'll be a warrant, should be reissued if it was withdrawn.
He was just here, Your Honor.
He said they told me he was here.
I'll check.
Okay, too late. You said go to the end of the docket. No, sir, I'm not hearing your case now. Go back out.
We'll call you later.
Call you at the end of the docket.
State of Ohio recalls Melissa Weaver, case number CRD 16490, PRD 10251. Your Honor, she's on Zoom. She was late out.
I'm here, Your Honor.
All right, Melissa Weaver is here. This is for a review. You still have fines and costs to pay. You did make a payment in October.
I made a payment today, but it was honestly only $7. I have to put money on my card and then I'm going to pay more today.
Okay. And where?
Oh, you also have people on the Blue Jeans app. I can hear them talking.
Okay. Well, we're not using that anymore, so I'll have somebody go check and tell them to get over to Zoom. All right, I'll set your next hearing for December the 4th at 9 a.m.
Thank you.
You're welcome.
Have a good day.
Good. Okay, we're going to the jail to do some arraignments now.
State of Ohio versus Christopher R. Smith at the Lawrence County Jail, case number TRD 231564, CRD 23647, A, B, and C, CRD 23561. This is Mr. Roger Smith's case.
Okay, this is actually, I guess, set for pretrial and preliminary hearing.
We have a proposed, I thought Philip was behind, a proposed resolution. I spoke with Mr. Smith this morning. One of the charges is possession. He has never had treatment. He indicates he has an Ohio medical card, and the state, I think, is agreeable. If he were to go to residential treatment with an ankle monitor, they would not oppose an OR bond, and Mr. Smith is interested in that.
Be waiting to the grand jury.
Wait to the grand jury, have an assessment.
So there's a felony charge, at least one, and then some misdemeanor charges all arising out of the same incident. So we would be sending those on to the grand jury. Now, we've also got a prior pending domestic violence charge. And it was, I believe, part of our agreement, or at least that was what I anticipated, that he would be entering a plea on the prior domestic violence charge, and we would agree to a 30-day suspended jail sentence.
There's also a traffic charge. He's got the domestic violence that arose September 7th involving, it must be his father because it's the same name, or it's a mistake.
It is, Judge.
Christopher Smith is the victim. Christopher Smith is the defendant.
Right.
And then there's also this traffic charge. Now, this arose at a different time. And it's, well, different from that. I don't know if it arose at the time of the second set. Yeah, it did. So this October 25th is the same day that the having the weapon and the
endangering children,
those charges. There's
yes,
a traffic charge. So you want to nollie it to the grand jury?
Yeah, I think it was the probably the thing that precipitated the rest of the
probable cause.
Yeah.
Okay, well, let's deal then with 23-561. How do you want to handle that, Mr. Smith?
Is that the domestic violence charge?
It is.
Chris, you heard what the prosecutor said on that misdemeanor would be 30 days suspended jail sentence.
Yes, sir.
Okay, so we will do a guilty plea on that, Judge, since it's going to be, the recommendation to be a suspended commitment to the jail.
All right, Christopher Smith, do you agree with your attorney, Smith? I assume there's no relationship there.
Not that I know, well, going way back, but no, not that I'm aware of.
Yes, sir, I agree.
Do you have anything you want to tell me, Mr. Smith, before I finalize this?
No, sir.
Okay. All right, on 23-561, I'll impose a $200 fine, which I'll suspend if he successfully completes treatment. Order him to pay the court costs. Now, there initially was a protection order. Is that going to stay in place to stay away from his father?
I think Jasmine's had difficulty reaching out to his father.
What we would want, Your Honor, is a no contact order, and then if he wants to lift it later. But we'll need to draw one of those up for him to sign.
Okay, there'll be a no contact order for Christopher Smith to stay away from his father, Christopher Smith. I don't know if there's a junior, it doesn't say, just both says Christopher Smith.
His middle name is Sean, mine's Ragged. So it's just, the same name.
Okay, it does say Christopher S. Smith and Christopher R. Smith.
Yeah, yes, sir,
Okay, Christopher S. Smith, he's to stay away from Christopher S. As in Sean, Christopher S. Smith. I'll set a review May 3rd of 24 at 9 a.m. Now, on 23-648 and 23-647, so 23-648 again was a misdemeanor. I assume you want to nollie that to the grand jury?
Yes.
So 23-648. We can make it level 5, since he's going to be in common pleas.
Okay, what was the other one now?
23,648 was a misdemeanor. It's a resisting arrest. So it's going to be nollied to the grand jury.
That's correct.
$23,647. He has a 15,000 cash or surety bond. I'll make it a 15,000 with ankle monitor, and we're going to need to release him to inpatient.
That's what we would anticipate. I guess probably before the court makes that order, maybe we ought to have him assessed this morning.
All right. Taylor, you want to assess him, and then we'll finalize that?
Okay.
So, Mr. Smith, I'm going to have someone call you from the treatment facility. First, I need to ask, do you have any objection to going to a facility that... wait a minute, I'm not finished. I'm not finished. You didn't let me finish my question to you. My question was going to be, do you have an objection going to a treatment facility that is faith-based? At least a part of what their philosophy is, that you need to work on your faith to remain in sobriety. And that's the Christian faith, as I understand. You're okay with that?
Yes, sir.
All right, the name of that facility is Bethesda. They're going to talk to you, and then after they do so, we'll have you back and we'll finalize what's going to happen on your bond and what you're expected to do.
Yes, sir.
We'll recall you after that happens.
Yes, sir. Thank you.
On this case, I do have an order the prosecutor signed to release the car to his father's car, and it's getting impound fees, and Mr. Holt, I agree.
All right.
If Dad shows up, they can release him if he pays the fees.
State of Ohio versus Keith P. Cremines. Case number CRA 23-420, CRB 23-431.
Okay, I need Taylor to come back in. Or somebody from, probably Taylor, she's the one in contact with that case.
Yeah, Krista.
Yes. All right, Mr. Cooper, don't leave the courtroom because I'm going to order Mr. Cremines locked up. He's back to the holding cell. I'll deal with you later. Okay, we're going to start pre-trials now.
Ohio versus Travis R. Valero, case number CRB 23-435. Mr. Holt's case.
Okay, now we need Mr. Holt in the courtroom. We need all the lawyers in the courtroom. Any lawyer that wants to have their case heard needs to come in the courtroom. I'm not hearing them out in the lobby or outside on the sidewalk. Okay, have a seat, sir. We'll get to you when we find your lawyers.
State of Ohio versus Harold Woolworth, case number TRC 23-1259, ABC, CRB 23-550.
Judge, Mr. Moore
Case
is
and
mine.
set today for pretrial.
That's correct, Judge. On my way in this morning, I received a phone call from Mr. Moore's wife. He is allegedly in jail in Huntington, so he's not here today. The state and I discussed how to address this, but ultimately it's up to the court, what you'd like to do.
I'd say issue a warrant for him.
That would be our request. I had suggested maybe that if the warrant could issue in 7 days if he's not here.
Right, there'll be a warrant issued in 7 days if he hasn't appeared in that time frame.
Thanks, Judge.
You're welcome.
State of Ohio versus Katrina Phelps, case number TRC 231182.
Mr. Stratton's case set for pretrial. Any idea where Ms. Phelps is?
Yes, she's here today, Your Honor.
Okay, we'll go to the end of the docket now.
Yes, sir. Sorry, Your Honor.
State of Ohio versus Victoria Stinson, case number TRC 231056 A and B.
Your Honor.
Victoria Stinson.
I don't believe she's here yet. This is set for noon. Yeah.
All right, that'll go to the end of the docket.
State of Ohio versus Allison L. Snyder, case number TRC 231100 A, B, and C.
Your Honor, may we approach on this?
Yes. Set for pretrial, Mr. Stratton's case.
Your Honor, this is and I had mixed her up with my staff.
All right, defendant's asking for a continuance. With a time waiver.
Yes, Your Honor. Your Honor, the only bad day for me would be the 27th, so.
Then?
Yes, that's fine.
All right, November 20th will be the next hearing for pretrial at 10 o'clock. And I see you've got Mr. Ashworth. Can we dispose of his cases?
What cases?
Mr. Ashworth, what cases do you have today?
Yes, sir, I have two today. I have one for Mr. Both my cases are with Bush.
All right, so Mr. Morford.
I don't know which one we're up on first. One was a 10 and I think one was a 10.
I have two with him earlier.
You know the names? What's the names?
Wilburn and Roadcat.
Wilburn and Roadcat.
State of Ohio versus Christopher W. Roadcat, case number CRB 23646 and TRC 211172 A, B, and C.
Yes, Your Honor, this case was recently assigned to me as special prosecutor. I spoke with the law enforcement officer and the victim this week.
Yes, sir.
I am going to add some charges to this one. You can probably set for another 3 rounds before we schedule trial. We don't hold it this one.
All right, and there was some issue with this, was it yesterday, Mr. Major?
Excuse me, I'm sorry.
With Mr. Roadcap, you were involved with something with Mr. Roadcap?
I did, but he was fine. It was, there was some communications with the GPS monitor that was a little weird, so I went out there and went to check. He was at work, but he did contact Carl Bone's office and it straightened out, Your Honor.
Okay, all right. All right, so it sounds like there's going to be some additional charges filed, so we'll just need to set, you're going to be instituting those charges, Mr. Ashworth?
Yes, sir.
What kind of time frame do we need to get that?
I'm done. 2 weeks is fine.
Mr. Ashworth, are they going to be similar type charges as what's pending?
Yes.
Thank you.
Okay, how about the 20th, the 17th, we actually have a jury trial that day, so I'm trying to not set any new cases that day. The 20th work, or actually the 22nd or 27th, 20, 22 or 27th?
20th, and 22nd or 27th, I have other obligations.
Mr. Moore?
Judge, November 22nd?
20th, 22nd, or 27th? We're looking at the 20th right now.
I'm here then.
Okay. I'll reschedule this for November 20th for pretrial, and it's my understanding there'll be additional charges filed. Anything further, need any admonitions or anything from the state toward Mr. Roadcat?
What's already been admonished to him to stay away from the victim in this case. He has a pending protection order, and we will expect him to reply to that.
All right, I'll reinforce that statement. There's no reason for you to be around the complaining party in this case. Is that correct?
You don't need to be driving past my house either.
Yes, sir.
Anything further, Mr. Moore?
Not here, Judge. Thank you.
All right, these cases are continued to November 20th at 10 o'clock.
Thank you, Your Honor.
You're welcome. Thank you, Mr. Ashworth, for that. And then we've got
State of Ohio versus Marvin L. Wilburn, case number CRB 23580. Marvin Wilburn.
Judge,
yes.
He says he's on his way. I've been texting him, and Mr. Ashworth and I have been talking since probably 8:30 this morning about this and the other one.
Do we need Mr. Wilburn here to
Yes, Judge.
All right. Mr. Wilburn is not here. His case actually was set for noon. So it's up to you, Mr. Ashworth, if you want to come back at noon or if you want to stay on until he gets here. Apparently he's on his way to the court, but he hasn't arrived yet.
Which lady's talking for a minute? I don't have any problem with just hanging out here. I'll have my camera on and my mic muted, and when he gets there and you guys are ready for us, just give me a shout.
I'll call Mr. Ashworth and let him know we're getting ready.
Let the bailiff know when you're ready to have a call.
Thank you, Judge.
State of Ohio versus Nathaniel C. Packer, case number CRB 23651.
Daniel Thacker is Mr. Stratton's case.
Your Honor, this is a domestic violence that we scheduled for today, we had Monday.
This is the one that had some issues about visitation with children and that sort of thing, so that's
It
why we
is.
brought it back quicker.
Yes, it is, Your Honor.
Did any of that get resolved, or is that all still hanging out there? It needs to be resolved.
Well, we set it today because the alleged victim in the case, I believe, wants to modify the protection order. Is she here?
Morgan Thacker here. If you can come up and talk to the prosecutor, please.
In addition to that, Your Honor, he's at PATH, getting services at PATH. I think it's going to be a 90-day dismissal, continued services at PATH, if there are no additional problems.
Okay.
So, Your Honor, Ms. Thacker, the alleged victim, is here. She does not want a protection order at this time. However, as a condition of that, she says that both of them have been going to PATH for marriage counseling, and that Mr. Thacker has also been receiving anger management counseling from PATH. And we would ask the court to order that we know she can't be ordered to go to marriage counseling, but we'd like to see that continued as a condition of this. And this is a situation that if there aren't any further problems over the next few weeks, probably closer to 90 days, and if the counseling is completed and court costs are paid at the end, then we would not have an objection to a dismissal of this.
We are fine with that, Your Honor.
And ma'am, that's correct, what's been represented. Do you have anything you want to tell me that hasn't been stated?
Your Honor, there was a protection order issued on
There
Monday.
was, and I'm making a note, I order this, it'll be withdrawn at her request. I think it's a good idea for the counseling, and I'm glad you're both going. I think it's an excellent idea. How about February 2nd as the next hearing?
Yes, Your Honor.
And if there's been no further problems, counseling's completed, then the case will be dismissed. February 2nd. Is that with or without cost, Mr.?
With cost.
We would ask for the costs.
Okay, so with court costs, so since there's no protection order now, the defendant doesn't have to appear if he's paid the court costs. There's confirmation that he completed counseling and no further problems. Then he doesn't have to appear. If any of those things don't happen, he's got to appear.
Your Honor, since it's February 2nd, I'm unsure whether PATH, his counseling and their services at PATH will be completed by then.
Okay. So better to have him appear?
Probably. Yeah.
All right.
I think it's
Next hearing, February 2nd, 10 o'clock. All right. Pre-trial.
Thank you, Your Honor.
And Your Honor, we'll have that protection order withdrawn here as soon as Jasmine gets back in the
Okay, thank you.
courtroom.
State of Ohio versus Daniel L. Cox. CRC 231103, CRA 23495, CRB 08425.
It's Mr. Smith's case set for pre-trial.
Judge, he's treating it PRO-ACT. We don't have a report. I don't know how that works with PRO-ACT anymore. He had one last time. You brought that with you last time.
I've got one dated October 12th.
Was it one last?
Yeah.
It seems like about a month ago. Yeah, that would be the one, Judge. And he's not, for whatever reason, they didn't give him one this time, but he represents you're doing well.
Oh, yes, yes. Yeah,
Still with
I'm
the
clean.
program.
I can take a drug test right now.
Well, and he has an ODI too, so how are we going to proceed on that?
He entered a plea to that on September 1st.
And I think we're just seeing how treatment goes before we sentence him. It's my understanding, Judge.
All right, I failed to make a note on that. All right, I need a report from PRO-ACT up to date. Since I don't have a report from them, I'd like for him to do urine screen today.
He's willing to do that, Judge.
Okay, go do a urine screen, we'll have him come back after that.
Yep.
State of Ohio versus Daniel L. Lucas, case number TRC 231414, A, B, and C. Daniel Lucas.
Yes. He's inpatient with RRS with ankle monitor.
doing well.
Yes, as well as I can.
Okay, sure.
You still have an ankle monitor on?
Yes, sir. I don't want the car. Okay. We don't want to forfeit it to the state. You want to get some money. Because I don't have to. I'll work.
How do you wish to proceed?
Your Honor, this is a third offense as it's charged right now. It's barely a third offense. We've also had two others outside of the last 10 years or so, but, you know, it's still, this is, if he's found guilty, it'd be his fifth lifetime, so we take this very seriously. And we're encouraged that he's in treatment, and we think that the continuing of the GPS monitor is appropriate given the severity of this. But at this point, I believe that, I don't know, Mr. Smith, have you filed for discovery?
I did. I just got it Tuesday or Wednesday. I still need to go over with him, and maybe next time we can talk about a plea.
So I would be in favor of a short continuance, and then at that time, for us to receive information about whether there's going to be a plea or whether they want to proceed to a trial. If he pleads, we would be in agreement to extending out the sentencing and letting him go through treatment before we make a decision about what we recommended to the court.
Okay.
Just the soonest I'm back here is November 27th. I've got a trial coming up in Common Pleas. Or I could do the 1st or 4th of December. I have some December.
27th is okay with the court.
Is it good? Okay, I can do that.
The state's okay with that.
November 27th?
Yes.
We don't oppose that.
All right, November 27th will be the next hearing, and expect to have a decision then as to whether there's going to be
Yes, I will read it.
admission, or we're going to go ahead with a plea and delay sentence.
Yeah, we'll go through discovery, Judge. Between now and then, I will advise the court, Mr. Hill, at that time.
All right, November 27th, 10 o'clock is the next hearing.
Thank you, Your Honor.
Thank you, Your Honor. Absolutely.
State of Ohio versus Suzanne Noss, case number TRD 20-261A and B, CRB 20-98A.
Susanna Haas. Mr. Smith's case, set for pre-trial. She's at PROAC also, or has been.
Sounds like she's been consistent. How did this case get so far?
The judge can answer this.
She didn't.
Yeah.
Oh, okay.
And then it came back on the background check, and then I contacted you guys.
And she turned herself in.
Yeah.
Okay. Looks like she's long-term with proactive, so.
She's,
Very long-term.
my understanding, I had a question about how it came to be that there was a lapse there of about a little over 3 years for her appearing in court. And she said during COVID, she just thought that, the case was not.
We were doing it over the phone, and I misunderstood something, and I was under the impression it was dropped, and it was not, obviously was not.
And she came to the court, we didn't have to find her. She realized when she found that on a background check, that she came in immediately.
This is a misdemeanor charge, and according to, I think, Marshall Health, it's an indication that she has been compliant. So I think at this point, I think that maybe we've reached the level and the extent of our concern for her well-being. So we'd go ahead and move to nollie this one.
Both the charges will be nollie at this point. It looks like she's in long-term recovery.
Yes.
Congratulations
Thank
on that. And so treatment in lieu of conviction essentially is what's happening.
Yes, sir.
here. So your case is dismissed.
What about
We'll dismiss it too.
There's nothing on my record. Thank you so much.
You're welcome.
Thank you so much. Absolutely, I got babies.
Okay, well, good.
I got babies to take care of. I'm not turning back.
Okay, don't turn back. That's good news.
Thank you.
Congratulations.
Thank
Keep up the
you.
work.
State of Ohio versus John F. Wright, case number CRV 23113. John F. Wright.
She's got to meet the court probably about an hour. Check.
John Wright.
John Wright is set for pretrial today.
Yes.
Your Honor, this is one that there are some other proceedings in common pleas court with respect to a community control violation that's been pending for some time, and it's been continued a number of times. However, it is still pending. It's set for a hearing on November the 8th. And so it involves the same situation that this is involved with. So we don't have a problem continuing this out until after November the 8th to see what the outcome of that was.
And I'm here to 27, Judge, if that's not too crowded yet.
Defendant's request, case is continued to November 27th for pretrial, 10 o'clock.
State of Ohio recalls Christopher R. Smith at the Lawrence County Jail, case number CRA 23647 A, B, and C, CRB 231564, CRB 23561.
All right, Christopher Smith is going to be interviewed by Bethesda to see if he is appropriate for inpatient treatment.
Your Honor, I did complete a pre-assessment on him. He is appropriate, and we do have a bed waiting for him today.
Okay, I'm going to modify his bond to $15,000 signature bond with an ankle monitor. So we'll need to have the orders entered for placement of the ankle monitor and contact adult probation to get that done. He's to be released only to Bethesda. And it's my understanding you're also waiving the preliminary hearing and agreeing this will go to the grand jury?
Yes, Judge, I believe they're going to fax the form up to the jail to have them sign the letter. I'll explain it to them.
Okay. Letters in the file. All right, so I won't be supervising then. He'll be supervised at common pleas.
Yes.
Okay. Now, what about the domestic? Do we want to, because how long will it take for him to get indicted?
Generally, we hold them at the end of the month.
So I'm just wondering, because he's going to have this domestic violence, I could bring him back on that to see how his treatment's going.
Oh, as far as sentencing?
For sentencing.
He pled.
Yes. I mean, I could sentence him and go ahead and have a review hearing
That'd be fine with me, because he's already entered a plea, sure.
Usually, especially when somebody first starts inpatient, we have them come back pretty early. It could be, I don't know how long it will be before he's going to be before the common police court.
You gave him a day of 5 to 3:24 for that.
Well, so I think we could modify that if the state thinks it's appropriate, or I can just let the common pleas handle it.
Either way is fine with us, Your Honor.
Okay, we'll let common pleas handle it then. We'll keep that the way it was.
Okay.
Thank you, Your Honor.
He's going to Bethesda, and his reviews will be set up by common police court.
Thank you, Your Honor.
Thank you, Judge.
Now, the child endangerment, is it going to the, not leave to the grand jury?
Yes. Excuse me.
He is getting sentenced on the domestic today.
Yes, 30 days suspended.
2 years probation. Okay, I'll just.
And what about this display of tags? Is it,
No, to the grand jury.
I'm thinking that's your probable cause.
State of Ohio recalls Marvin L. Wilburn, case number CRB 23580.
All right, Mr. Wilburn is now here. Mr. Morford's his attorney. Mr. Ashworth is special prosecutor.
Judge, I think that Mr. Ashworth and I have reached an agreement where he would move the court to dismiss the charge on Mr. Wilburn paying costs.
All right, Mr.
No,
Ashworth.
that's correct. I spoke to the victim several times. She believes this to be somewhat of a misunderstanding, frankly, and she does not want this to go forward. She's asked it to be dismissed.
All right, and can Mr. Wilburn pay the costs today? All right, see the clerk pay the court costs and it'll be dismissed. So that completes everything you have, Mr. Ashworth, I believe. Thank you.
Thank you.
Thank you, Your Honor.
You're welcome.
State of Ohio recalls Daniel Cox, case number CRA 23495, TRC 231103.
All right, Mr. Cox was ordered to do urine screen, which he did, and his screen is appropriate. Thank you for that. So we'll continue this out another month or so.
Another month, fine, Judge. I'm here the 4th or the 8th of December.
Let's make it the 8th of December. Pre-trial
I know it's not your fault.
and review on his older case. He did make a payment recently on that. Okay. December 8th, the next day.
Thank you, Judge.
Your Honor,
Good job, sir.
I'm making a note also here that we wanted to have a report from PROACT.
Yes, try to get us a report next time you come back.
Yes. Thank you.
You're welcome.
State of Ohio versus Sheena Darby, case number CRB 1449, CRB 13963, and others.
Stiers case.
Okay. Well, I can't really, I'm gonna take the phone upstairs, so let me look at it real quick.
Yeah.
This is the provider's cell phone, has her drug results, the drug test results are appropriate.
Okay.
They're on the printout level though, so.
Okay, that's fine.
Okay.
I'll get it printed off next time.
Thanks.
Sorry.
It's all right. And your name?
Deidre Wilkerson.
Okay. Gilkerson? Okay. And Your Honor, Ms. Gilkerson is a representative of Lodestar, and she has given me a chance to look on her cell phone. They don't have them printed out, but we do have her, Ms. Darby's drug test results, and they are appropriate. There were several sets there, and I showed them to Mr. Heald, who agrees that they're appropriate.
Yes.
I mean, the drug test reflect the medicine from the MAT, but nothing else in her system.
Mr. Hill.
That's what it appeared to me.
All right, state satisfied?
Yes.
Okay. You look good.
Thank you.
Let's keep it up and come back maybe a little more than a month. December 8th.
Let me make certain, I don't think that should be a problem. Yeah, that should be fine, Your Honor.
December 8th will be the next hearing. 10 o'clock. Let's make it stick this time. Good job.
Thank you.
Thank you.
Thank you, Judge.
State of Ohio versus Amy Dement, case number CRB 23606. Amy Dement.
Your Honor, there is a companion case, Philip Thacker, that could be called together.
State of Ohio versus Philip N. Thacker, case number CRB 23607.
And Mr. Stier is representing both Ms. Dement and Mr. Thacker.
Your Honor, after discussions with Mr. Heald and Ms. Dement and Mr. Thacker, the state has agreed then that in exchange for a plea of no contest with stipulation of facts sufficient to support a finding of guilty, that the state would recommend a $100 fine and court costs. And the state's agreeable that one set be paid between both cases. If the state.
One fine and one court cost?
Yes.
And do we agree on whose case?
I didn't actually really could talk about that. The fine and court costs will go on one or the other of you. Do you care which one it goes on, or?
I don't care. I don't care. I just want to pay the fine and get it over with.
Okay, well.
I just paid my dog. I just want to pay it and get it over with.
Your Honor, I don't think it matters.
All right, I'll place it on this Dement's case then.
Thank you.
$100 fine and court costs on Mr. Thacker's case. You can show a conviction, but no fine or court costs. And that'll be paid today?
100?
Well, there's, court costs will be, I have a, court costs is at 110 when there's not a appointed fee?
Yeah,
I believe, so it'd be $100 court cost, $110 court cost, $110 court cost, $100 fine.
210.
210 total.
Yeah, just pay it, I get it with, I'm done.
Okay, we can get that paid
Pay it
today.
today, no probation. Mr. Hill.
Your Honor, I'd like to say something on behalf of the state. These same individuals had an incident back in February of this year with a dog. I don't know if it's the same dog or not. I'm assuming it was. It was running at large on the same property as the victim in this case. So we have that incident that did not result in a conviction. And now we have this one. The third one will make the dog a dangerous dog according to the statute. And we will seek forfeiture of the dog and jail time if there's another incident. We're taking this very seriously.
And it ain't my dog. I know the lady's dog it is.
Your Honor, the situation we have, Miss DeMint has told me that she does not believe that her dog is the dog that was responsible. I discussed that with her. I told her, we could have a trial if she wants to have a trial on that issue. That's a perfectly reasonable issue to have a trial on. She said she wanted to complete the case today, which is why I spoke of doing rather than a guilty plea, I did a no contest plea. And she's now concerned about that, so I want to make sure you understand that this goes down as a conviction, and if we come back again on a similar issue, there are greater problems down the road. Not today, but down the road. So if you want to have a trial, I think the court may allow you to withdraw that no contest plea.
Can I say something?
You can, but I'm going to advise you that anything you say can be used against you.
I don't care. That's fine.
I know, I just need to be.
I have proof that it's not my dog. I have a lady call it right now and say it's your dog.
Okay.
It's not my dog. She said that she's gonna lock it up, and it's on my property that's on.
Then I'm not going to accept your plea then. I'm
Thank
going to withdraw the plea and we'll set this for a trial. To do the trial.
Can I just pay the court costs, and if something happens?
Ma'am, you just told me you're not guilty, so the court is here to do justice, not to make it convenient for you.
No, just forget it. I'm done with this.
So,
Your Honor.
You want to make a statement? You told me you're not guilty, so I'm going to withdraw your plea.
He's leaving next month for court, and he can't be here. Can I come for him?
You're leaving.
He has to work out of state, and
Well, what sort of a time frame is that?
he works for
Okay,
a
Mr.
government.
Sutter, let's do this. Go talk with these folks.
I'll
and after you
ask to have the matter recalled, Your
come
Honor.
back and we'll
Thank you.
finalize that.
Come back in a minute.
Ask them what kind of dogs they have.
What kind of dogs do you
No,
have?
not in here.
No, that's
Outside.
well,
Let's go outside.
Deal with that out there. I'll talk to you in a minute.
Or to the attorney room.
Well, just go back and do I have another case about to be called? I'll step out then.
State of Ohio versus Richard Dennison, case number CRB 23543 A and B.
All right, this is Mr. Morford's case set for pre-trial. Mr. Morford, how do you want to proceed?
Judge, I understand Mr. Hill would like an opportunity to view the video, and he also wants to speak, I believe, again with the victim's family, I should say, Judge.
Yeah, I think it's important, and especially in this case, to make sure that I know how the family members are feeling about this. I have reviewed the video, and I'll review it again, but we would benefit, I think, from a short continuance.
Okay, is there any time issues on this? It's a second-degree misdemeanor, so what's our time frame here?
Well, second-degree misdemeanor is 180 days, I believe, but
Well, July 23rd is when this allegedly happened. I'm not sure, the arraignment was well after that.
yeah, the case was filed on September 6th, and he was summoned in on September 22nd, so sometime during September. I prepared a time waiver.
We'd waive time, Judge, we don't have a problem doing that.
Okay. Well, that solves the time issue. So, for the court, the best times to come back would be next Thursday, the 9th, the 20th, or the 27th of November.
Judge, or do you have a Friday in those dates?
I do not. I can go, it'd be December before we could do it.
Could we do that? I'm asking for his work schedule.
Yes. December 1st?
I'm here then.
That's a Friday. Finished with class cases continued to December 1st for a pretrial at 10 o'clock.
Thank you.
You're welcome.
State of Ohio versus Joseph R. Sherman, case number CRB 23248.
This is Mr. Morford's case set for pretrial.
Your Honor, do you have a report dated November 3rd from Pat?
No, I do not. The last one I have from Path is September 14th.
Coming at you in just a second. Madam President.
Yes. Is this mine or?
Yes, you can do that.
It's a good report. How's the state want to proceed?
Well, the state's encouraged by the fact that he's keeping up with his counseling. This is not a situation where we will necessarily want to dismiss the charges, but at this time, if he were to enter a plea, we would not oppose a suspended jail sentence and let him continue on probation and continue with his treatment.
Any interest in that, Mr. Moore?
They're not doing something? I'm sorry. They put his on for it. He's on no jail time, complete treatment. That's fine.
He's going to take Mr. Heald up on his offer, Your Honor.
All right, so there's a change of plea then?
Yes, to guilty.
Please, which can? Guilty.
Yes, Your Honor.
Do we need any input from, was it Bentley, I believe, Ms. Bentley?
Well, her input has been that she primarily was concerned about a protection order, so we'll be asking for a no contact order. She was not interested in seeing jail time in this, but she wanted him to continue with his treatment, but she also believed that there should be a conviction. So that's her input.
Anything you wish to say, Mr. Sherman?
No, Your Honor.
All right. I make a finding of guilty on his plea. So at this time, I'll enter a no contact order. If she wants to drop that, and she's a relative of yours, she'll have to come back to court and ask for it to be dropped. It'll be a $100 fine, court costs, 10 days in jail suspended, orders stay away from Sherry Bentley, and continue with treatment at PATH. 2 years of level 5 probation. I'll set your next review hearing. I'll give you a couple months before you have to come back and get a report in. Do they give you the reports to bring with you to court, or how do you get those?
They have not given me nothing.
Okay, how'd you get this, Mr. Moore?
He handed it to me, Judge.
Yeah, they sent me from the jail to his office.
Oh, okay, they sent it to Mr. Morford's office?
They sent me, that's all I did when I got out.
Okay. I'd like to get the report somehow, if you can make that happen. Talk to Mr. Major about it. So you're going to be on probation, he's your probation officer. And so I'm going to set your next hearing for January 8th.
That hearing.
See Mr. Major, and you're free to go after that.
Yes, sir. Hey, Judge, you got time. This is the no contact order.
State of Ohio versus Stephen Stanley, case number CRD 23-148, CRD 22-184A and B, CRD 19-33-37A.
You doing all right, buddy? How are you? Good. Yeah, I'm fine, yeah. It's great. It's great. Yeah, it really is. Yeah, there's more out there than you know what I mean? Okay. Sometimes you don't have to lean on.
No comment.
All right, Mr. Stanley is at Bethesda. Compliant with treatment. You still have an ankle monitor on?
Yes, sir.
Mr. Morford.
Judge, we'd like to continue on course. I think he's benefiting from being at Bethesda. He's clean and compliant, and we'd like for him to finish. I believe he has maybe about 30 days, Your Honor, to the end of inpatient. I'm sorry, 130.
Okay. Anything you wish to say, Mr. Stanley?
I appreciate the opportunity. I feel like I'm also benefiting from it. Maybe possibly you could take a monitor off. That'd be lovely.
It goes either way. Sometimes I best clients will take it off the room, and sometimes I'm worst clients will take it off the room.
That would be me.
So he's been a good client. I mean, we can try it. It's on him.
Okay. I'll order it removed. That's another step in this whole process. But to say this, and I never know with folks until ultimately they get down the road and decide, is this something I want to make a way of life for myself and my family? Or am I only doing it because I want to stay out of jail? You know, I'm okay with people starting the process because they want to stay out of jail, but at some point to be successful, you have to adopt this as your own way of life. So this is one of those moments because I have had people that are in a similar situation as you, take an ankle monitor off and they leave.
Right.
And but you have to decide, this is not for me. I mean, it is in the sense that I feel like I'm tasked on behalf of the community to try to get the best result for you that I can. But ultimately, it's for you, your family, and you've got kids, right?
Yes, sir, I do.
And how old are they?
6 and 8.
This is a really important time for them. They're already watching what you do.
Yes,
and I know you want to be with them, but you being with them clean and being in recovery is a lot more important than you being with them right now.
Yes, sir.
So long range, we got to think long range. So when you're tempted to leave or relapse, you need to think about them.
Yes, sir.
Because we know statistically that if you're using substances and your kids watch you, and they know what you're doing.
Yes, sir.
And they're going to know, as they get older, they're going to know even more. They know what goes on in the house. Their chances of using go up. You're modeling behavior for them. So use that as a motivation.
Yes, sir.
I'll wear the ankle monitor removed. You're doing great. Keep it up. Adopt this for yourself. And we'll see you back on December the 8th. Mr. Morgan?
That's good here, Judge.
December 8th.
Thank you, Your Honor.
See Mr. Major about getting the ankle monitor removed.
Thank you, Your Honor.
You're welcome.
Thank you, Judge.
State of Ohio versus Travis R. Valero, case number CRB 23435.
Butch.
All right, this is Mr. Holt's case, pretrial.
Your Honor, we are going to make sure we have the alleged victim here the next time to have a further discussion about how we're going to proceed, and we will contact him, probably issue a subpoena also, and so we'd like to have a short continuance in order to be able to do that.
Okay, in November, Mr. Holt, what I'm looking at is the 20th is getting bad now. We could do it tonight, that's probably too short, that's next Thursday.
I could do the 13th.
13th is pretty bad.
Okay.
20th is pretty bad, 17th is bad, 27th is okay.
That's fine, sir.
27th? That's a Monday. That's agreeable?
Yes, Your Honor.
November 27th will be the next hearing,
Thank you.
10 o'clock.
State of Ohio versus Randy Thompson, case number TRC 231301, A and B.
All right, Mr. Morford, you're going to be representing Mr. Thompson?
I've been retained, yes, Your Honor.
All right. Set for pretrial today?
We're not going to be able to do much of anything, Judge. Excuse me. I was just hired, and I'd like to have a short continuance so we can serve discovery on the state.
27th of November or go into December?
What's best with you?
27th of November is fine, as of now. It's filling up. That's an open, relatively open date.
I've got several here with you then, Judge. We're going to do it on the
November 27th will be the next hearing, 10 o'clock.
Thank you, Your Honor.
You're welcome.
Your Honor, I noticed that this case arose on September the 5th. I don't know, I don't have any record of when he was arraigned, if that was...
September the 8th was the arraignment date. I think he's asked for a continuance a couple of times, I believe. He was going to hire Mr. Hicks, and that didn't happen. So at least from October the 6th to November 3rd today is at his request. Is there a time waiver today, or
We'd waive time, Judge. I don't have a problem doing that. He's out on bond.
time waiver today?
Thank you, Judge.
You're welcome.
State of Ohio versus Stephen Dennison, case number CRB 23612. Stephen Dennison.
Is it set for a pretrial today? you have a lawyer, Mr. Dennison?
I do not.
All right, how's the state want to go forward?
The people are behind you want to subpoena.
Okay.
The lady from, Catherine and the victim.
Hi.
Joshua Bowman.
So, now, where do we stand with this? I understand that when he was asked to testify, he gave conflicting so, So, Your Honor, the alleged victim in this matter is a special needs individual, and I have with me here a representative, Ms. Purdie. She's from the DD board, and the gentleman is, I'm sorry.
Joshua Bowman.
Oh, you're Joshua.
Yeah.
He's the alleged victim. So he's in a different living arrangement now, not with Mr. Dennison. And we're going to have some issues maybe getting to the bottom of things, but the first thing we wanted to ensure was that if there have been problems that need charges in this court, that we know exactly what's happened. And we don't know everything at this point. And so we would be okay if Mr. Dennison would agree to a continuance of about 30 days. It would allow us to make sure that things settle down a little bit, we don't have any problems, and then get to the bottom of exactly what we're dealing with. And we would agree and suggest that maybe we should come back maybe towards the middle part of December, if Mr. Dennison's in agreement with that.
Right, Mr. Dennison, what's your position, sir?
Well, I don't understand why. Josh has already admitted in another court that these charges were false. And it's putting me through some health issues, just worrying about, thinking about things that never happened that he's charged me with. Why do we need another 30 days? I mean,
I can set it for a trial if you want to have a trial.
I'm sorry?
I can set it for a trial if you want to have a trial. It doesn't sound like the state's ready to dismiss it at this point.
And Your Honor, frankly, the reason why we were seeking to move the case out a little bit is to, just so the court knows, there was a protection order sought for Mr. Bowman, civil protection order, and because of certain differences in the testimony from what was alleged in the petition, that was not granted. Now, we're dealing with a kind of a different situation here. And so we're just trying to make sure that we don't have a problem, that we just want to know what all the facts are before we agree one way or the other. We understand Mr. Dennison's situation, and really, frankly, if he wants to go ahead and have a trial, we can go ahead and do that, but I think the better way to handle it is what we've suggested.
Mr. Dennison?
I don't really understand all the court issues and all that. It appears that maybe I should accept the court-appointed attorney so I can have some advice.
Okay, so you wish to be considered for a court-appointed lawyer?
Yeah, that's what I was told at the last hearing, was that
Do you have any income? I have to ask about your financial circumstances.
Yeah, I've got my Social Security.
That's your only income? How much is that a month?
It's around 2,500.
Okay, how many people in your household?
3.
And are they working?
My wife works, yes. My mother lives there. She's on Social Security. She's 83, so she has a little check coming in, but not much.
What's your wife do? You have to look at your household.
Okay, she's LPN, the Veterans Home.
What's that? I don't know what an OPN is.
I'm sorry?
I don't know what an OPN is.
LPN. Nurse.
LPN.
Yeah, I'm sorry.
Licensed practical nurse. So what is she paid by the hour also?
Yes.
You know what her hourly rate is?
So, I'm guessing right around 22.
Is she working full-time?
Yes.
Well, she's making over 40,000.
Yes.
Okay, well, actually, even for a household of 3, you've got more income than what I'm supposed to appoint counsel for.
Okay.
So, I'm not going to appoint counsel at this point. The state's not even, it sounds like, I'm reading between the lines. I know you're not a lawyer, but in fact, you're representing yourself since you don't have a lawyer. It sounds like there's still a chance that they may not go forward with this case. They're wanting 30 days to look at it further. And now you're welcome to have a lawyer anytime you want, but I can't
I'm not
appoint.
trying to be hard to get along with. I just don't understand, and if that's what is needed to, I mean, I know I'm not guilty, so I guess they just need to prove it.
Yeah, except the state has to prove, they have to prove beyond a reasonable doubt if it goes forward.
I would like to say this, that the allegation has arisen between Mr. Bowman and Mr. Dennison, and I believe Mr. Dennison might be his stepfather. Is that the relationship? Or what's
I'm
the
an uncle by marriage.
Okay, uncle. Well, the very fact that this allegation's been made, and also the fact that I've learned that Mr. Bowman has a residence that he can move to, and that services will be provided through the DD board. And if that were to be made a permanent arrangement, it might resolve some things within their family that could keep future things from happening. That's what we're looking at as well. Now, it's not to say that having him move will definitely resolve our issues, but it certainly could not hurt.
Well, I'm assuming they're not cohabitating now. Is that
Right.
Okay.
There's people living in the house now.
But you're evicting them, right?
I evicted them, yes.
So that can go a long way in resolving this. It's just going to take a little bit of time to figure out exactly where we stand.
Okay, I'm going to continue this then at the state's request to December 15th for another pretrial at 10 o'clock. That's all.
Is that it?
State of Ohio recalls Amy DeVent, case number CRB 23606, and Philip N. Thacker, case number CRB 23607.
All right, so we took a break to allow Mr. Sire to talk with his clients.
Your Honor, I heard you say that the 17th is not a good day. However, Mr. Thacker is going to be leaving the area for work. So if we're going to set a trial on this matter, I have a witness that I'm going to need to subpoena. I'm just going to give Mr. Heald a preview of what I'm expecting to hear there, which is that while they have a Great Pyrenees, that Great Pyrenees is tied up, and there is a second Great Pyrenees that does not belong to them, that is wandering the neighborhood. I've spoken to an individual who says, yeah, that's my dog, and it gets loose all the time, sorry. And I'm going to subpoena her and have her testify to that if there's a trial on this matter. If the court and or Mr. Heald are agreeable to Mr. Thacker not being set for that day, and then we can deal with just with Ms. Dement, we can pick a different date, but if we're gonna try this thing with both of them in anything approaching the near future, is gonna need to be the 17th.
Mr. Hill.
Well, if there's two Great Pyrenees in the same area, that probably is a rare thing. Those dogs are, especially large, and I don't know how common they are. But if there's another person who's willing to say, yeah, my dog's running at large, then what we would want to do is send the same deputy out to talk to that person, and maybe we would determine that that's the dog as opposed to their Great Pyrenees, in which case that would change things. If they want to go that direction, if they want to give me the name and the contact information of that other person.
Yeah, I'm happy to give you that information.
Brittany Love, 4702 County Road 12, Proctorville. In the same neighborhood. 4702 County Road 12, Proctorville.
And could you do me a favor? Could they take pictures of their Great Pyrenees?
I've got pictures of the other one, and I'm asking them to get pictures of theirs.
You got a phone number for her?
I don't. Do you have a phone number for her?
Who, Brittany?
Brittany? No.
I'll give it to you. Didn't I?
No, you just gave me the address.
Hold on, let me see.
I'll get that from her and
Right.
provide it to the state.
Let's do this. Can you have this done within 10 days?
Well, I'm going to ask a law enforcement officer to follow up, so I would like to.
Let's ask them to do it by the 13th.
The 13th is fine. I would assume I can get, I'm going to do the recipe today. I assume that I'll get the subpoena in time to get her here.
All right, November 13th for a pre-trial. We're having a jury trial on the 17th, so I'm not going to set it for.
Oh, that's fine, Your Honor. I understand.
If it's not resolved the 13th, we'll pick another date.
Got to come back on November 13th.
November 13th for pre-trial.
And if
Well, I'm not going to subpoena her to court then for the pre-trial.
I'm going to have the deputy go out and see.
We'll deal with it. We'll try to deal with it separately.
And we'll need a time waiver. What date will we move it to, the 13th?
November 13th.
I don't have it yet. I don't know the other one.
Thank you, Your Honor.
What's the phone number?
Oh, okay. Thank you.
State of Ohio versus Ryan J. Plants, case number TRD 23-1591, and CRA 19718, CRD 19719.
Your Honor, may I approach?
Yes. Okay, we got to start, it looks like.
It's like a foothold.
How do you feel about Mr. Plants?
Great.
Good,
I heard him talk yesterday. It's a good start.
good. Okay, we'll come back.
Yes, sir.
27th, I know you're here then.
I'm here on, yes, November, yes.
November 27th, be the next hearing.
Looks good. We'll see you then.
10 o'clock, November 27th.
Thank you, Judge.
Thank you, Your Honor.
State of Ohio versus Jason L. Turner, case number CRA 23638.
Now, Treasurer.
Yes.
stay at all these places. I understand.
Well, I think today we need to do a screen. Let's do a screen for him. Looks like things are going the right way, but I want to see what the results are on the screen. So go do a screen, come back.
State of Ohio versus Christy L. Jordan, case number CRA 23549.
Christy Gordon she was the one that was in a rehab in Kentucky. She's been appearing by teleconference. I wonder, let's have Mr. Major check to make sure she's not on the blue channel. Christy Jordan. I'll recall that later.
Is that Mr. Steyer's case?
And I've got Steyer, and Meadows is representing her in common pleas. Is Mr. Steyer?
He just left the room.
Need Mr. Steyer, maybe he knows something. We'll recall.
State of Ohio versus Victoria Stinson, case number TRC 231056 and B.
Your Honor, this is set for a trial today, and we're going to enter a plea of guilty to the charges today. I believe the state's going to recommend minimums on everything on this case.
Your Honor, it's first offense, breath test is .108.
All right, Ms. Stenson, your attorney represents you wish to change your plea to guilty, is that correct?
Yes, sir.
You have the right to make a statement, you're not required to. Do you have any statement or explanation you want to make before sentencing?
I messed up and I had a hysterectomy and it just totally flipped my mind until my doctor got me on some medicine. I couldn't control my emotions.
Okay.
It never ever will happen ever again. I promise you that.
Well, it's good if we learn from our mistakes.
Oh, I did. I'm learning.
People don't never learn from their mistakes, so that's part of life. Okay, I'll impose the minimums, $375 fines, the minimum, or you pay the court costs, 6-month license suspension, and that'll start the day of your incident, so you've got quite a bit of your suspension already taken care of. 20 days in jail, I'll suspend all of that on the condition that you do 5 days community service, and you have to go to the driver intervention program. Unfortunately, we don't have one here in Lawrence County as of now. We had one for many, many years, but it went out of business. So the closest one now is in Scioto County. You can go to any one that's approved by the state of Ohio, but that's the closest one in Portsmouth. Mr. Major can explain more about it, give you some information. It's a 3-day program that you got to go stay, but it's better than going to jail.
Yeah.
They either have to give you jail or you have to finish a 3-day treatment program. So.
I'll do the treatment.
And they do it at a hotel. That's a lot better than going to the jail for some days. You do have proof of insurance. Are you working?
Yes, sir.
I'll give you a permit to drive for work purposes, to come to community service, and to go to the 3-day school. Any other works or any other driving situations you need a permit for?
Would that require an additional entry, Your Honor? She already has an entry for driving privileges.
Well, this is gonna trump that. That's over now, so this, she'll go by this entry.
Okay, is that, the court will issue that?
Yes.
Okay. Oh, also, Your Honor, she does, could you explain that to me?
I have a granddaughter that I raise, and I transport her to school and back, and so...
Okay, I'll just put for childcare.
Okay,
thank
you.
Your Honor.
The best thing to do is don't get pulled over.
Best thing to do is never do it again.
Yeah, well, I'm talking about even the little stuff.
Oh, absolutely.
You know, use your turn signal. That's a pet peeve of mine. People don't use your turn signal. Stay within the speed limit. Do all, stop at red lights. Then if you get stopped on a traffic and they run your license, you're gonna have some explaining to do.
Okay.
Because it's gonna show up that you're suspended.
Right.
And then you got this piece of paper from me saying, the judge says I can drive. It's better not to get pulled over and have to make that explanation, right?
Absolutely.
So just avoid things that cause you to get pulled over.
Right.
It's pretty simple.
Absolutely.
Okay, failure to control, $20 fine. Was there anybody else's, it was just your car, wasn't it?
Yes.
Yeah.
Your single car wreck?
Yes.
Okay, I think that's it. And
Thank you so much.
See Mr. Major in the probation office, and you're free to go after that.
Thank you.
And your review is May 3rd of 24. 9 o'clock.
Okay, well, he suspended the time, so that's, it is, you are.
State of Ohio calls Freddie L. Adkins, case number CRB 23-437.
Probation officer. Yeah.
This is Mr. Stratton's case. This had been set October 3rd.
Yes, Your Honor. Mr. Atkins had brought in some medical paperwork here where he was at St. Mary's. So I'll just ask that this be reset for another pretrial.
Well, here's another problem. I have a report from Bethesda as of October 9th through October 15th, they were non-compliant.
Your Honor, I think that day we was in court, he was not compliant when we spoke with, when the outpatient director called him for a screen and said he was riding his bike and he just didn't have time for it or something like that. I don't want to quote specific, and I thought we had set it for a trial after that. Is that, am I?
No, never set it for trial.
So you're a bike rider?
Yes.
Motorcycle? Or?
Motorcycle.
Huh?
Motorcycle.
Oh. Well, you don't get any sympathy on that.
Your Honor, do you have case number 23-631 on him?
I do not.
Okay, he has a warrant on that.
Okay, let's pull that. And I think he needs to do a urine screen. One of the things they say is you didn't come in for screens when you were asked to.
We're
All
willing.
that random BS, said you were on a bike ride. Well, if you're on a bicycle ride, I might say, okay, I can kind of see that, but a motorcycle ride? No. Go do a urine screen and come back.
Yes, Your Honor.
State of Ohio versus Katrina R. Phelps, case number TRC 23-1182. Katrina Phelps.
Your Honor, can we maybe approach on this for a second?
Yes. Mr. Stratton's case set for pretrial.
They went to find the, he had, I have it up here. He has a warrant on domestic violence, position on 10/17.
So that's a new charge.
Look at that.
Right, he didn't show up. He came today. Maybe he's not qualified. Maybe he's not qualified. Maybe something anyway. He's not here for you. Sure. All right, it's my understanding on Ms. Phelps, there's going to be a change in plea.
Yes, Your Honor. We'll have a plea of guilty to the charges, Your Honor. Let her explain a little bit about the situation and what occurred for the court to understand.
All right, Ms. Phelps, you agree with Mr. Stratton that you want to change your plea to guilty?
Yes, sir.
And you have an explanation or statement you want to make?
Well, I know this sounds far-fetched, but I was at a party, I ate a marijuana brownie, and here I am.
Didn't have any marijuana in it, though.
I know.
Had stuff other than marijuana in it.
Right.
Right.
I mean, I gave the brownie to the officer because I honestly thought that it was a marijuana brownie, and it annihilated me.
So you knew you were messed up.
Oh, yeah.
Well, as I often say in this court now, the way things are in our community right now, you can't take anything that somebody gives you off the street because you have no idea what's in it.
I know, because I worked really hard.
You're lucky
Get where I'm
that
at.
it didn't have fentanyl. I mean, there's fentanyl and all kinds of stuff that's out there in the community now. People are dying because of it. I mean, even fake pills. I mean, there's pills, somebody says, you know, back in the day when I was growing up, well, I got a really bad headache. Well, here, take grandma's hydrocodone, or she's got these left over. You can't do that anymore because it might be fake pill. You don't know that it's even legit. It could have fentanyl in it. They're stamping out fake pills because they can sell them a lot. 70, 80 bucks a pill. If you say it's OxyContin, and it's not. It's just a bunch of crap with some fentanyl in it. And people are dying because of it, because they're not mixing them in a lab somewhere. They're mixing them in a warehouse or a garage. Not being done by scientists. So you don't know what you're getting, what dose you're getting.
And it's sad.
It is sad.
Because I willingly ate a marijuana brownie, but I did not willingly eat what was in it.
Well, here's the thing. This is, this offense, maybe this is more than you want to know, but for the record, it doesn't require an intent. You don't have to intend to be impaired. You just have to be impaired. There's some criminal offenses, it requires an intent, a criminal intent, to be a violation of the statute. This is a safety statute, so if you're messed up because somebody gave you something and you took it, then you're still in violation because you could hurt yourself or somebody else out on the highway. So, Mr. Hill, anything you want to say on this?
Well, I think that Ms. Phelps is taking responsibility, and she's ashamed that it happened, I believe, but I think she can benefit from this going forward. This can end up being a good thing for a person if they look at it that way. So hopefully she won't have any problems going forward.
I don't think
As far as
she
the
will.
sentence goes, we do have some concern that there was the meth in the brownies, which I've never heard of that before, but you know, if it happens, then she needs to be careful, but it might be a situation where she could benefit from some extra counseling just to make sure she doesn't have a bigger problem.
Your Honor, in this situation, I don't believe there is an additional problem. I believe this is a one-off incident, inadvertently digesting these drugs.
Okay, well, here's what I'm going to do. I'm going to insist that she go to, if she wants to avoid counseling, she go to the driver intervention program and do it immediately, because they're going to evaluate her for if she needs other treatment.
Yes, sir.
And if she does, then I'm going to require she get it. But I'm not going to let her wait a year to go to the dip school. She needs to do it right away.
Yes, sir.
The entry is going to say 60 days, so I'm going to enforce that here. She's got to get there within the next 2 months, get an evaluation. If they say, oh, this was a one-off, I don't think this is ever going to happen again, I'll be okay with that. But if they say there's indications of problems, she needs additional counseling, then she's going to have to get the additional counseling.
Yes, Your Honor. She just started a new job, but in a couple months, she should be able to do that.
Okay. Anything else you want to tell me, Ms. Phelps, before I finish your sentence?
I won't be marijuana brownies anymore.
Good idea. Marijuana brownies that are not marijuana brownies.
Right.
Okay. I'll give you the minimum fine. I'll believe your story that it wasn't intentional, so I think I can take that into account on your fine. So I'm giving you the minimum fine, $375. Order you to pay the court costs. Your license suspension, 6 months, and that starts today, because that's the first week. You didn't have an automatic license suspension until today. 20 days in jail, all suspended. On the conditions, you do 5 days community service and go to the driver intervention program, and I want you to do it within 60 days. You do have proof of insurance, so I'm going to give you a permit to drive during your suspension for work, community service, to go to the dip school. What else? Anything else?
I pick my granddaughter up from South Point, like
Okay, for child
3 times
care.
a week.
Child care. And you heard what I said about the other person. Just don't, I mean, you got a lot of explaining to do if you get pulled over. Just don't do stuff to cause you to get pulled over.
Yes.
Because you're going to show up as suspended with a permit from me to drive.
Oh.
Since we got this whole issue of the dip school, I'm going to set her for, I'm not going to go to May. I'm going to set it in February. So I'm going to set it for February the 5th. It's her review hearing. So I want you to have been to the dip school by then.
Over to probation.
Well, let's, because usually that's the beginning of the month. So let's make it February 12th, I'm sorry. Because that might be around the time that they're having it. It's one of the ones in February. So February 12th will be your review hearing at 9 o'clock. She has to go see Mr. Major in the probation office.
Yep.
And after you've seen him, you're free to go.
All right, there you go. Okay, over there.
Thank you.
You're welcome.
Right here, okay.
State of Ohio versus Clarence Mayhem, case number CRD 20-988, CRD 21-187.
Mr. Smith's case.
It is, Judge, and we had some updated discovery that we received yesterday. I need some time to go through with my client. We would waive time. I'm here the 27th. It's getting a little bit crowded. Can we do the 1st or 4th of December?
December 1st, at defendant's request, will be the next, and you want it as a regular pretrial?
I think a trial. We've pre-tried it. It's unfortunately going to have to be a trial. We're just at loggerheads.
All right, noon for trial on December 1st.
Thank you, Judge.
Let me check and make sure you don't.
Get here to
a good day.
Get here to let us we can talk.
Yes, that should be a good day. December 1st for trial, and
Thank you, Judge.
State of Ohio recalls Freddie L. Atkins, case number CR 23437 and CRB 23631.
That's the new case. Okay, you had a good screen.
Great.
There's a new charge. Have you seen it, Mr. Stratton?
I have not, Your Honor. I believe it's domestic violence, is that correct?
It is. What?
Approach?
Yes.
This is copies?
Yes.
Brooklyn Rigger
It's an
here.
M1 domestic violence. All right, Mr. Atkins, I think at the last hearing you talked about maybe hiring counsel. Are you going to do that, or do you want to continue with Mr. Stratton?
I'll continue.
And are you employed now?
Yes.
Where are you working?
A one-stop truck and trailer repair.
Are you paid by the hour?
By the day.
How much per day?
$100 a day.
Do you have any children?
Yes, I have a son.
Okay, you're still eligible for court-appointed counsel, then? I'll appoint you, Mr. Stratton, on the new case.
Yes, Your
Do you wish me to read the charge into the record?
No, Your Honor, we'll waive reading, enter a plea of not guilty.
He has a bond up on his other case. What's the state's position on this case as far as bond goes? And that, he's got a domestic in that. Let's see, that's in for same victim.
Same victim. I was just looking for the date of the previous, July 17th. I don't know what the status of the protection order is, if there's one in the prior case. I don't guess there is. We've had contact with the alleged victim, and you know, she still wants Mr. Atkins to get counseling as he's doing, but it kind of elevates this thing when you've got a new charge after you've already got one pending. Not to prejudge it, but by the same token, we have cause for concern. I actually don't know at this point whether our alleged victim wants a protection order in this case.
She's not here today, I think.
She's not. She said she would try to be here if she could get a ride, but she's not here. But we spoke with her on October the 24th. Well, that would have been for the last hearing. Anyway, so we need an updated, I think, input from her as to whether
Is she reachable by phone?
I think she should be.
Your Honor, I just received the court, the indictment and the facts of the case. I think the prosecutor might want to read the facts of this case, this new case, and maybe base your decision on that.
Oh, okay.
And we are willing to work with him in treatment. He just needs to.
My extra brain told me some things that I now remember.
Did you have further input then?
She was here, Brooklyn Rigger was here the last hearing on the 30th. And,
Which would have been after this incident, allegedly.
Yes, and she was upset because he hadn't been arraigned on the new one yet.
And he didn't appear on October 30th.
Right, and we actually, there is a protection order in place. So we've got that taken care of.
So there is a protection order. Is he not residing with her then? He should not be.
No, Your Honor.
Okay. So I don't need to continue then.
And Your Honor, I'd just like to note for the court on consideration of bond, that the narrative here speaks of her breaking a car window, initiating the situation here. So I hope the court will take that into consideration and allow him to sign his own bond, that it appears that she is the aggressor here.
Well, I don't think that's what the affidavit says, but I've read it myself.
We're going to get more input from her, from Ms. Rigger, In the meantime, the fact that Mr. Atkins is in treatment is a positive thing. We've got a protection order in place. We're not asking that he be put in jail today or anything like that, so.
Is he being compliant now, or, I mean, the last report was not very good.
No, but
Quite a bit of an attitude from him.
I'll speak with him after he walks out of here and we'll get him straightened out.
Okay.
How do I contact her about seeing my son?
You don't. You're not allowed to contact her.
I've actually got more updated information, and that is that we heard from her on the 31st of October, and that she's mad as a hornet and is not being very forgiving at this point, so.
Well, why don't we do this? So apparently you've got good contact information for her?
Yes.
At that point, he hadn't been in court. Let's contact her today, see what her position is, what's occurring, and then we'll recall it and finalize bond and next hearing date. And ask her about visitations. How old's your son?
5.
So, do you have a suggested neutral third party to handle visitation?
Yes, her mother.
Your mother?
Her mother.
Her mother? Okay. Let's talk about that with her, and then let's recall it and see if we can iron some of this out.
All right.
Thank you, Your Honor.
That's all right. I may recall.
State of Ohio versus Dylan Python, case number CRA 22473, TRC 222096A and B.
All right, and we've been continuing this sentencing while Mr. Hyden has continued in treatment at Bethesda. Okay, it's a good report. It says there's still stuff to work on, but you're not going to jail this weekend, so that's an improvement, right?
That's an improvement.
So hopefully that last incident triggered a new attitude and...
He's got a new understanding, I believe, Judge.
Okay, very good. We can all learn things, so I think he learned some stuff from that last incident. At least I hope so.
I agree.
Looks like you're on the right track. Let's keep at it. And I think he still has a ways to go, doesn't he? Or what's his?
A little bit, yeah.
Okay. December 11th?
That's good to hear, Judge.
December 11th is going to be your next hearing. Keep up the good work.
Thank you.
You're welcome.
Thank you, Your Honor.
Thank you, Judge.
You're welcome.
State of Ohio versus Brian Montroso, case number CRB 1733, CRB 15543A and B, CRB 14593, TRC 111387. Brian Montroso.
Montroso is not here for sentencing. And I believe he's got a warrant out. Yeah, he has a bond up. And I'm sure Mr. Sowers knows where he is. Set a bond forfeiture hearing. November 27th.
Thank you, Your Honor.
And I want to know if he knows where Emily Smith is.
I'm sorry, you want to know what, Judge?
If he knows where Emily Smith is. Anything further on her?
Your Honor, I spoke with her mother about 3 days ago. She reached out and asked for my number and said she was going to call me, but I think she just really wanted money. But supposedly she is with him at his house or in that trailer park still.
State of Ohio versus Heather Blevins, case number CRB 23158, PRC 23261, A, B, and C. Heather Blevins.
Heather Blevins. I've got Ms. Scott as the attorney. Sentencing. Pre-trial and child endangerment. Neither one are here, so let's have the clerk's office call Ms. Scott.
There's a special prosecutor on that case. Looks to
There
me
is?
like. Well, that's what my notes indicate. Heather Blevins. Is that 23 TRC 261?
Yes, but I don't have any notes on that. Hired Christine Scott on both cases.
I think she's counsel for the defendant, not special prosecutor.
I just texted her, Your Honor.
Okay.
State of Ohio versus Taft Maynard, case number TRD 231138, A and B.
Set for sentencing.
Your Honor. Mr. Maynard has a matter pending in common pleas court. I'm not his attorney on that, but I know he has one pending. I'm not sure. I'm going to look and see if I can find out who his attorney is. He's not here today. But he may be incarcerated from common pleas, or he may have been placed in a treatment facility or something like that, and not be able to get here. So
I'll recall it then.
I'm going to see if I can do a little bit of digging and find out a little bit about his whereabouts.
Thank you.
Thank you. Taft Maynard.
State of Ohio versus Jared Rognon, case number TRC 212826, A, B, and C, and CRA 21597, CRB 21598.
Mr. Steyer's case. Mr. Rognon has been at Southern Hope.
Your Honor, yes, I have an updated report for him here. He's in New Life Recovery.
Yeah, I guess he was there last time.
Okay.
Yeah.
Have you gotten the, you said your problem from the CDC, have you got the other class done? No. Or your schedule? No, maybe it was January. You're set for January? Okay. Have you? Oh, you haven't? Okay. I just started working. I know, I understand. As long as you're working. Yes, but I don't have to get here.
Okay. Your Honor, he's doing well in treatment. He's actually going to begin CDCA training at the next class that begins through the program. And then we still have the OVI class to get done. He's working on getting the money together for that. He's just started working. reached the point in his treatment where he's able to work. Where are you working?
IHOP.
He's gotten a job at IHOP, so he's going to be able to get some money together to pay for the, for the dip school. So we're working on that, and then he's just basically doing pretty well, I think. Seeing that he's in school, and we're getting a lot of progress. I've been on this case for quite a while. It's been sort of stretched along, and I've seen a real transformation in Mr. Rognan.
Mr. Hill, how do you want to proceed?
We're okay with him continuing on in his treatment, and we're encouraged by the progress he's made.
Okay. December 18th.
Oh, let me check my calendar, but I don't think that should be a problem, but let me make 100% sure. Nope, I'm actually on the docket already.
Okay, next hearing is December 18th. Pre-trial and preliminary hearing.
10 o'clock. Thank you.
Keep it up, Mr. Rognan.
Thank you, sir.
You're welcome.
Please have a good day.
You too.
State of Ohio versus Jeffrey A. Trout, case number CRB 21-900, CRB 21-602.
Okay, this had been set for October 30th, and Mr. Trout was not here then. Is that correct?
Yeah.
Do you have an explanation?
Yeah, it was raining and I had to catch the bus and then ride about 1.5 to 2 miles to get here. I didn't have no ride.
Where are you living now?
Canova.
Canova?
Yeah.
Okay, do you have any payment on your one case is paid off, 21-602 is paid off, 21-900 is what you still owe. Do you have a payment today on that?
I can pay 50 right now.
Okay. Make a payment with the clerk. I'll set your next hearing for December 1st.
Could you at least try to do December 4th or something, just to make sure, because...
Fridays aren't good, or what?
Well, my son's birthday is the 2nd, and I get paid on the 1st.
Okay, I'll set it for the 4th, December 4th. $9 December 4th.
All right. Thank you, Your Honor.
See the clerk.
State of Ohio versus Zachary Alberts, case number CRA 22-389, CRB 21-347.
Okay, Mr. Alberts is here on a warrant. You left treatment some time ago, right?
Yeah, I paid off the funds that I had, and
Are you clean now?
yeah.
Okay, go do a urine screen, and we'll see what that shows us. Go do a urine screen.
All right.
State of Ohio versus James McClellan, case number TRD 21-682, TRD 18-11-68, TRD 16-35-21, A and B.
Okay, this is the docket on failure to appear for a review hearing. He had a review hearing back in June. Didn't appear for it, and he's coming in now on warrants. He's in treatment.
Yes.
And he's been at Regal, he's been at Mahajan, and now he's at
Restoring Hope,
And when did he come there?
on the 27th, sir.
Of October?
Yes,
Inpatient, outpatient, or,
inpatient.
and how's that going?
It's actually going very well. It's only been a week, but he had asked me to find out what he needs to do to get back in here, and he made the calls himself, and he's here.
Okay, well, the first step and start, I'll withdraw the warrant since he came in on his own, and
Appreciate it.
set your next hearing for November 27th.
I paid all my fines too.
Very good. And remind me again what the name of the facility is?
It's Restoring Hope Recovery Care.
Okay, next hearing is November 27th at 9 o'clock.
Thank you, sir.
Thank you.
State of Ohio versus Alexis Kane, case number CRB 23502. Keith Kermees will be next.
So we did get a valid.
We finally got a screen with the temperature and a color. And it's positive for alcohol. We
Which is a
struggled.
problem, right?
Yeah, we've really struggled with getting food screens and getting treatment. And the last time we were here, we did give her until today to be compliant, and she's still not.
Well, would you rather do a month in jail than go to treatment? Yes.
I do remember coming in 2 weeks ago and they told me that I had to be compliant. And I should have shown, like, all my screens have been clean this whole 2 weeks, except today. I couldn't find myself to get the Vivitrol shot yesterday. And after talking with my doctor, she had recommended the same method. And so I did have a drink an hour after I took my shot, which that was against my medication. And we don't take full responsibility for that. But the rest of my screens are clean. I've been under the group. I've been doing all my ICs the last 2 weeks like I'm supposed to be.
Well, when you get called for a screen, you have to come in. You can't tell them you're not going to come in.
Right.
Are you still willing to work with her, or?
I mean, we're willing to work with her. I truly believe that she needs to go inpatient, but
Could I get maybe 1 week? And then I will guarantee that in the screen, I will complete a day of my community service and also get all my clients. But I understand, you have been very lenient with me, and I appreciate that, and I'll take full accountability, not just having that drink yesterday was wrong. I shouldn't have done that, but if I could just get a week, to show you that, I'm on the right track.
I'll set it for 6 days, so November 9th. You'll be back here at 9 a.m. and I want a good result, and that's because there is no court on the 10th, so I'll see you next Thursday, November 9th. And then after that, if you're still messing up, you go to inpatient. Okay? You're welcome.
State of Ohio versus Keith P. Kermees, case number CRB 23430, CRB 23431.
Your Honor, may I approach?
Yes.
This is lab work from our send-offs for Mr. Kermees. And you can see where there's prescribed medication. And then on 10/30, he had a send-off, and there was absolutely nothing that was found in his system. The next, on 10/24, he had a send-off, and there was just buprenorphine found in it and not naloxone, which means that it was scraped into urine. His next one his one before that on 10/16 shows all of his medication. On 10/15, it shows that he's completely clean. On 10/12, 3 days before that, it shows all of his medication again. I've spoke with the lab the tests are tampered with. We actually sent him for a hair follicle test, and paid for it out of our own pocket, but it only tests for 4 different things. And, every time that there is a medication passing in the house, he's been involved in it. At this time, we're just going to move to discharge. I've spoke with Shawnee. They're willing to take him, but can't take him until Monday.
What say you, Mr. Cremines? Okay. I'm going to remand you into custody and put you on the docket for Monday, the 6th, and he's to be held without bond, and then we'll decide Monday whether you can go to Shawnee for treatment. But you've been, if these things are true, you've been a kind of a terror there, interfering with not only you're interfering with your own sobriety, it sounds like he's interfering with other folks at the...
He was actually the one that passed the Seroquel to Caleb Langdon that caused him to run.
Okay. All right. You'll have a weekend in jail. I'll see you on the teleconference from the jail on Monday, and we'll decide then whether you get to go back to treatment or stay in jail.
Thank you, Your Honor.
Thank you.
State of Ohio versus Brian K. Stapleton, case number CRB 23593, CRB 22573. And CRD 23983 ARD.
Okay, this is a recall on Brian Stapleton. Got the new case. Initially, you failed to appear for arraignment on October 27th. How's the state want to go forward on this new charge? This is the one where she was here this morning.
Yeah, a lot's happened this morning. I remember her, but I don't remember exactly. Is that
It's an assault charge.
And if I recall correctly, it was from some time ago.
September 13th.
Yes. And I wish I still had the file out here. Ryan Stapleton's file. Oh, okay. I don't recall if he has other pending cases or not.
He has some old cases. He's got a restitution that he owes on a theft offense, and he failed to appear on it also. And he had a review on a traffic matter, no operator's license, he failed to appear on.
All right. I don't believe that there was a request for protection order in that case.
I think she actually wanted to dismiss.
Yes, so if he's going to be brought back in on reviews on those other cases in a reasonably short period of time, I don't know whether that's scheduled or not, but we would like to have a pretrial on it in the not too distant future.
Okay. So you're working now, Mr. Stapleton?
Yeah.
When did you start that?
I started that about 4 or 5 months ago.
Okay. Are you paid by the hour?
Yeah.
How much per hour?
16.
How many hours a week?
We work about 40 to 60 hours a week.
Oh. Okay. How many people in your household?
3.
Who are they?
Me, my wife, and my daughter.
Did your wife work?
No.
All right, Mr. Morford, I'm going to appoint you on this new case. I'll let Mr. Stapleton sign a $5,000 signature bond. No protection order at the victim's request. And I'm making it high because he's failed to appear in the past.
John?
Yes, sir.
We called court, and the lady that my wife talked to said that it was all right, as long as I got to that.
Well, if she said that, that's wrong. I would say that was your interpretation. I think what they probably told you is, if you don't appear, you've got 7 days before a warrant will issue. It doesn't mean it's okay that you didn't show up. It means that there's going to be a warrant in 7 days. Not that it's okay that you don't come.
I was trying to get here.
Okay, November 27th will be the next hearing for pre-trials and review hearings. Pre-trial and
Reviews at 10.
yes. Okay, he can be released. You're welcome. Thank you. You're welcome.
State of Ohio recall Zachary Alberts, case number CRA 22389 and others.
Okay, good screen.
Yeah.
All right. What's going on with you? Where have you been all summer, or half the summer? It looks like half the summer.
Just been home, really.
You're not working or anything?
Doing a little bit of side work.
For who?
Myself.
Like what kind of work?
Just like trimming trees, brush, stuff like that.
Are you living with your dad now? Or?
Yeah.
Okay. Are you getting any counseling?
Yeah, I have a doctor, I'm a therapist, Ellen.
Where? You got a report on it?
Family Medical Centers.
Okay. Mr. James, can you get me his report? Now, you still have stuff in the common police too, or you finished there?
Yeah.
Because one time you did, didn't you? Down in Ironton, at the main courthouse, didn't you have a case down there too?
Yeah, I did, yeah.
What happened on that?
I got taken care of.
So this Dr. Rahman is who you're seeing now?
Yeah, that's what I was saying. That's who's prescribing the medication.
That one report from Rahman, there's a report from Dr. Rahman. Okay, I'm going to have that placed in your file.
Okay.
Report from Dr. Rahman. Okay, based on your screen and the report from him, I'm going to say your cases here are completed.
Okay.
So get that report back, and then you're free to go.
All right.
Mr. Cooper will bring it back to you.
Okay.
That's all.
All right.
State of Ohio recalls Jason Turner, case number CRA 23638.
Okay, it's an appropriate screen for Mr. Turner. And what's your availability in December?
The 1st, the 4th, the 8th, or 15th.
December 1st. Preliminary hearing December 1st, 10 o'clock.
Thank you, Judge.
Continue with your treatment.
Thank you, Your Honor.
You're welcome.
State of Ohio recalls Pat Maynard, case number TRD 231138 A and B.
Mr. Steyer's case set for sentencing.
Your Honor, I spoke to, I did some research, apparently Mr. Davenport is his attorney. I contacted Mr. Davenport. He's not aware that of Mr. Maynard being anywhere that he couldn't be here, but I think the confusion might have arisen from the fact that his other case went on to the grand juries, who might have thought this went with it and misunderstood. He is scheduled to be in front of Judge Ballard on Wednesday. I'm also going to be there Wednesday, and I found a phone number for him and sent him a text message. I'd like to see if I can continue this for about, maybe to the 13th, and ask to have a chance to get him back in here.
Okay, defendant's request continued to November 13 for sentencing.
Thank you, Your Honor.
You're welcome.
State of Ohio versus recalls Christy L. Jordan, case number CRA 23549 and CRB 23551.
Miss Jordan was to be on the teleconference. I don't know if anyone's on here. I don't know if she might have been on.
There is nobody on Blue Jeans. Mr. Majors checked twice.
Okay, well, she's been in contact with me all morning saying she had been on there. Maybe she jumped off when I told her to switch to Zoom. I thought she was changing to Zoom.
We'll check right now.
I do have a report for her in the form of an email from Courtney Fugit from Oxford House, where she's currently attending treatment, stating that she's attending required meetings, and it says she's emailed to inform me that she's still a member of Oxford House, Knoll, which I guess is the location, and she is still attending her required meetings. Ms. Fugit apparently was at the hospital in an emergency, but was contacted by Ms. Jordan and sent this email, so it's not really in the form of a formal report. But I can forward the email to you. My thought would be to reschedule this thing, and if I could get her the information for the Zoom. I don't have the Zoom information. I had the old Blue Jeans information, could send that to people, but I don't have the Zoom information. I'm not even really sure what is involved in getting somebody onto Zoom.
I assume just send them the link.
Yeah, there's Ask Missy or Vivian out there. They have the
Okay.
number and whatever she needs to get on that.
There is no one on Blue Jeans right now.
How's the state want to proceed?
It sounds like Mr. Steyer's gotten some confirmation that she's still there.
She's had good reports before.
What I'm trying to remember is, it seemed to me like there were cases that did we forward these to the grand jury?
She has something that's at the grand jury, I believe. I believe she went to the grand jury through the other court with a different attorney. But I don't have anything with her in
And I just looked it
Constable.
up, unless Christie gets spelled a different way.
And I think it was misspelled initially on this, so.
So we're not opposed to a continuance on this, and we'll figure out what's going on in common police court.
December 4th.
I'm available that day, Your Honor, and I will get the information. I assume this is going to be like the Blue Jeans where we have a single code that remains.
That's my understanding. This is the first day we've used some.
Two numbers, there's two groups of numbers that we're putting in.
But it's going to stay the same from week to week. It's not going to have
I believe
to.
so.
Okay.
Ask John Major, he'll know, but I believe so.
December 4th will be the next hearing for preliminary hearing.
That is correct, Your Honor. The meeting number and passcode number will stay the same for every court hearing.
Okay, thank you.
I'll get that information to her. And you just go to like Zoom, is it a website or an app?
Yeah, you download
Depends if it's on a phone or
it.
not.
Okay.
Phones and app, the computer would be, you got that downloaded.
Okay.
State of Ohio recalls Freddie Atkins, case number CRB 23631, CRB 23437.
We took a pause on this to let the state try to get in touch with the complaint program.
And we did, Your Honor. And she's serious about, especially now there's been a second offense. So she's wants us to pursue the charge, which we will. As far as the parenting time, she says that, and I believe this is probably appropriate, that there needs to be some orders in domestic court. There are none. And she has no opposition to following whatever orders will be issued by the appropriate court. I don't know whether the parties are married or not.
Yeah, we're married.
So,
Is there a divorce filed or any kind of?
No, not yet.
so that's what we would think is the appropriate thing, is let that court deal with parenting issues.
Okay. I can't order her to do anything. She's not before me, so if you want to exercise your visitation rights, you can get an order from the appropriate domestic relations court.
Yes, Your Honor.
When do you want to come back for the next hearing?
Maybe a couple weeks, Your Honor. Not the 27th. 27th is a bad day.
No, they're all good to be.
I have a trial that day.
How about the 22nd? We haven't said anything on that day yet.
Yeah, that sounds good, Your Honor.
Well, it's a Wednesday now. Can you be here on Wednesday?
If you just give me 1 second, Your Honor.
Because Thanksgiving's the 23rd.
My 22nd is fine, Your Honor.
Okay.
One second.
February 22nd for pretrial.
I guess he's allowed to sign his own bond on this new case.
Yes, and he's got a bond up on the other case, so I'll let him sign a $2,000 OR bond on this case, so.
Just get with me about the.
State of Ohio versus Brittany D. Lively, case number TRC 23799, A and B.
All right, this is Mr. McCown's case set for oral argument.
That's right, Your Honor.
We
It's
have,
like we just here, Your Honor. She's out in the
For Freddie Atkins.
hall, if I may.
Yeah.
is set for argument today. Since the state has the burden of proof, you wish to argue first, Mr. Green.
I would first, I guess Mr. McCown wants to argue instead of just submitting the briefs, which is fine with us. And we would, Your Honor, we submitted a brief back on October 5th. Hopefully the court's had a chance to look at that. I believe that the question that was posed was, what is the standard of proof required for the officer to remove an OVI suspect from the vehicle for field sobriety testing? And our response to that, I think it's pretty well supported in the law, is that it has to do with reasonable suspicion, and it has to do with the totality of circumstances. And that means everything that the officer collects as evidence, as clues to the possibility of impairment, starting with their initial observations of the person when they're still in their car driving, and the officer sees what they believe to be a reason to stop the car. It is true that if, for example, a person is speeding and they get stopped for speeding, that alone is not necessarily a sign of impairment until other factors start building in. Then they smell the alcohol, then they see the bloodshot eyes, and so it becomes the totality of the circumstances. So I think it's, in this situation, the officer witnessed several different signs of impairment, which I believe that we cite in the motion, which I believe that it's the court's, as the finder of fact, it's the court's, let's see. As the finder of fact, the court is to determine whether there are sufficient clues of impairment that rise to the level of totality of circumstances and reasonable suspicion. Now, reasonable suspicion is not the same level as probable cause, and so therefore, it doesn't take a determination by the officer conclusively that the person is impaired in order to get him out of the car to then initiate the field sobriety test. We believe in this case that there were substantial bases to remove her from the car, and it is a case-by-case basis. It's for the court to determine. On review, on appellate review, the appellate court is not going to disturb the trial court's judgment on the facts that led to reasonable suspicion, absent something that an abuse of the discretion that the court has over the situation. So we feel in this case that the officer was completely justified in removing Ms. Lively from the car to then conduct the field sobriety test.
Mr. McCown.
Thank you, Your Honor. Your Honor, there are actually two issues that the court requested us to brief, and I've filed my brief in response to Mr. Hild, and I'm happy to answer any questions. I don't know if the court has had an opportunity. It's been crazy, I know, this day, but if the court has any questions, I'll be more than happy to answer that as well. Mr. Hild is correct that it's totality of the circumstances and reasonable suspicion. As we indicate in here, there are 58 cues in vehicle in motion and in phase 2 personal contact that an officer can observe. In this one, Trooper Beam, who's here today, I think on another matter, indicated he observed 3. He said he saw he thought bloodshot eyes, that there was an odor of alcohol, and he asked her, "Hey, I smell alcohol, have you been drinking?" "Yeah." She said she had 1 glass of wine. Without going through all those, and I'm happy to go through what the state alleged in their memorandum, if the court would like me to, but without going through those, I would note that some of those, through cross-examination, Trooper Beam said, yeah, those actually are not cues. Some of these things that I've listed in my report and that have come out incorrect are not cues for impairment. And I think and I note this in my memorandum contract, there was this claim of she slurred her words on 1 sentence out of the entirety of the evening, Mr. Hill referred to that. I don't think the court can consider that. I don't know what weight the court would give that anyway, because it was allegedly one sentence, 2 words in one sentence out of the entirety of the evening. But that was done after she was ordered out of the car. And so therefore would not be a factor in this. The court saw the video. The things that you look for as a trooper, and the same things that the court would be looking for, are there obvious signs of impairment? And if the court recalls, she already had her insurance waiting for him, handed that to him. They had a conversation. He would ask her questions. She would stop, look at him, answer, and then go back, and without additional prompting would continue to look for the item that he asked her to retrieve. If the court recalls, there were, I'm exaggerating, but it seemed like 10,000 napkins everywhere stuffed in this car. She gets them all out, goes to him, locates the registration in this, and before she answers says, oh wait, let me make sure this is the correct one because I have my old registrations in this. Goes through, finds the date on this paper with the registration, verifies, and hands him the correct one, which he acknowledged. She also, when he asked her then for her ID, gets a stack of cards out of her purse that had store cards and credit cards and other things, goes through, thumbs through them without fumbling, without them going everywhere, gets to her driver's license when he said ID, takes her driver's license out, immediately hands him to him and stops. None of this is indicia of impairment. In fact, this is how, as Trooper Bam acknowledged under cross-examination, this is how a normal sober person reacts under that circumstance. And so, as it comes to this reasonable suspicion, again, there was no improper driving. That was never alleged. It was just a simple speed. She was one of 2 cars that was going that he estimated she was the rear car of it. He pulled her over for speed, indicated she didn't have any problems pulling over. She reacted appropriately throughout the rest of it. The second issue that the court asked us to brief is the Harrington issue. That's actually a 4th District case that we raised. That's State versus Harrington. I refer to that in my memorandum as well. And in Harrington, much like what happened here, the trooper in Harrington testified, here's what I did for the field sobriety tests. I did this, I did this. And what our 4th District said, based upon Ohio Supreme Court case law, I believe it's Condalupi, Your Honor, that they refer to in it, State v. Condalupi. And they say, well, that's great, but that's not good enough. The statute says these can come in only if the state shows, by clear and convincing evidence, that the officer substantially complied with the standards. And it talks about the NHTSA standards in that statute. The 4th District in Harrington specifically says, well, okay, but to show that he complied with the standards, it's not enough just to state, here's what the officer did. You have to put the standards in. There has to be a comparison to show that they substantially complied with it. And Harrington indicated basically there's 2 ways. They can either go through and testify, here are the standards, here are the standards, here are the standards, and then you talk about whether they complied with them, or they could place the manual into evidence and here are the standards. Those weren't done in this case. There were a couple of exhibits that were given on parts of it. I would indicate to the court, though, that I don't believe those exhibits that came in actually go through the entirety of the testing requirements and why, as far as the times, distances, and all of that, scoring, all of those functions. And so I believe under 4th District case law, under Harrington, that again, it should be suppressed for that basis, even if the court finds that there was reasonable suspicion to move from this investigatory stage into the pre-arrest screening phase of phase 3. Thank you, Your Honor.
Your Honor, and I did also brief the issue of the Harrington case, which I neglected to speak about before. The officer went through the testing procedure for each of the tests. He gave examples of how it's to be performed and what he's looking for, what clues are there for. He testified that he has been trained and certified, and that's part of his employment with the Highway Patrol. And we did offer parts, relevant parts of the NHTSA manual, which he identified as correct, into evidence. So we feel that we met that requirement easily. I would also mention, too, that we don't believe that, and we don't think the case law supports this idea that the number of specific clues that the NHTSA manual mentions are the limit of an officer's ability to collect observations to develop reasonable suspicion. It's been pointed out on this case and other cases that speed is not on the list, so you can't count speed. But our point is that if speed alone, if that were the only thing alone, then you can't, or if the smell of alcohol was the only thing you saw, then you wouldn't be able to count it. But when you accumulate, which is what you're supposed to do, with reasonable suspicion, then, yeah, speed can matter. Person was not paying attention to the speed. I mean, it's natural. Just because they were going straight and weren't swerving off the road doesn't mean that it's not something that is an indicator of potential impairment. And so we feel that, and along with the speed, there were several other things that we believe give rise to reasonable suspicion in a reasonable person's opinion. The windshield wiper, that's another thing. We got speed, and you got the windshield wiper was still on even though it wasn't raining anymore. Ms. Lively's eyes were watery and bloodshot. She had slow speech. There was the indication of the slurred speech. There was a minor incident where she maybe lapsed in her ability to maintain divided attention while she was interacting with the officer. She admitted to drinking alcohol. And it was close to 1 a.m., which we believe also factors in time of day. She said she'd been working and then she was at dinner, and it was long after those hours that any of those things would have happened. So we believe that the issue of whether there was reasonable suspicion is not even close.
Judge, I don't normally ask for rebuttal, but I didn't go into all those factors because he didn't.
They're in my brief.
Well, during his oral argument, I mean, if he's going to address them, I would ask for under 2 minutes to kind of address them.
Under 2 minutes.
Okay. Your Honor, first is, as to the speed, this is not, there's the old Latin maxim, post hoc ergo propter hoc. In other words, hey, because it followed it, therefore it must have caused it. You can't go back and retroactively use speed as a factor. Mr. Hill's saying, oh, after you've got all these other factors, then you can. No. Secondarily, as to the windshield wiper, the court's aware, I pointed out in here, we saw the video with the beaded water all over the car still, where she had been coming up the highway from Huntington. She had indicated she had been at the Texas Roadhouse to him. As to those other factors, Mr. Hill even today didn't say what that divided. Oh, she had a lapse on a divided attention skill. He didn't put it in his memorandum what that was. He didn't state it today. I actually, because of that, went through all these other factors as to what she did correctly. Again, as to the slow speech, and I addressed that in here first, that's not a cue. Second, it wasn't slow speech. It wasn't she was stumbling or fumbling in her words. What the trooper specified up there, he goes, well, wait a minute. I define that to mean she stopped and paused before she answered me, which is exactly what we tell our kids, our clients, everybody, students, everybody in life to do. Stop and think about the question before you answer. That is not slow speech. What Mr. Hewitt is attempting to do, and the state's attempting to do, is take all these factors, we believe of normal behavior, and then say, well, because we think she was intoxicated, it should be able to count as indicia of intoxication. That's not what the case law is. That's not what NHTSA standards are, which are adopted by statute, 451119D4, says that they have to adhere to NHTSA standards as they go through this investigation. So again, and as to Harrington, we do not believe he did that. Yes, he testified, here's how I tested them. There's no question he did that. But what those standards were, that was never asked by the state, that was never put into evidence. Thank you, Your Honor.
Thank you, Mr. Kim, and this case will be considered submitted. I'll read further the briefs, do my own research, and issue a decision.
Thank you, Your Honor.
Thank you, Your Honor. Court's adjourned.
All right, we got, I think,